by the Attorney General of Northern Ireland Abortion Services Safe Access Zone, which is now in place?
Yes, I'll have a go.
Yes. Good morning, my Lord. Good morning, my Lord, my ladies. Yesterday, before we rose, I was submitting that the bill and clause 5.2a should and could, in principle at least, only be operated in a manner which is compatible with convention rights. As we've seen from Mr McLennan's submissions, the bill provides the framework for the provision of safe access zones and the associated penalties, but they can only be sought and granted if justified in the particular circumstances. Therefore, as I was submitting, it cannot be said that in all or almost all cases, clause 5.2a is only capable of being operated incompatibly with convention rights, and therefore the provision is within the legislative competence of the Assembly or incompatibly in a legally significant number of cases. The fact that, as the Attorney General for Northern Ireland notes in paragraph 18 of the core volume, tab 4, page 30 of the electronic folder of her case, not all operators will be public authorities. That doesn't mean that the high threshold for a provision of being out with legislative competence because it is incompatible with convention rights is reached. Even in the instance of a private authority, they may request a safe access zone after having carried out a proportionality exercise, albeit they are under no Human Rights Act obligation to do so. So even if they did not, that, in my submission, doesn't translate to there being an incompatibility in all or almost all safe access zones. That is why, at paragraph 12 of my written case, I submit that there's no need to build in a reasonable excuse defence to clause 5.2a. That is at page 72 of the electronic folder. My position is that in individual cases, assuming a safe access zone is established, there may be cases where a prosecution and/or a conviction of a breach of clause 5.2a may indeed be disproportionate, and may be a disproportionate interference with the protesters' or accused rights under Article 10 and 11 of the Convention. But each alleged breach would be addressed on its own particular facts. And indeed, that's what the European Court of Human Rights highlighted required to be done in the case of Lashmankin that we looked at yesterday, which is at tab 21, volume 2. And we would particularly refer the court. Okay. Thank you. So, I'm sorry about that, my lords, my lady. I was looking at page 1055 of the electronic folder and paragraph 430 of Lashmankin.
Just before you go there, if I may. So your submission is that even if we were to decide that this bill is convention compliant, nevertheless, there may need to be a proportionality assessment on particular facts.
Yes, that's so.
Are you able to help us with any examples that you have in mind where that would be so?
Yes, so I have thought about that, and I have identified a number of examples where that may be so. Give me one moment.
I mean, I wouldn't want to put you out of your stride now, but if at some stage you could help us with that, I would be most grateful.
Yes, I can do it now, my lord, if that would be helpful, given that the question is asked now. If you just allow me one moment. Yeah. So So I have a number of examples. So, for example, I looked at a situation where a friend or relative who accompanies a woman to the premises, who then seeks to influence her, may well be able to argue that any criminal prosecution of that act of influencing is disproportionate. For example, this draws on the Northern Ireland debate, where it was argued that a mother may accompany her daughter and try to persuade her to change her mind, and who would then be subject to criminal prosecution. That was
The only people subject to criminal prosecution were people other than protected persons. So wouldn't the mother and the friend be a protected person?
Yes, but that particular example I'm drawing on might be a mother that wouldn't be invited to accompany. So there might be such a situation where she is not the protected person's requested support. That
So
might...
you're envisaging she might be standing protesting?
So I'm not talking about protesting, I'm talking about seeking to influence her not to go ahead and have the abortion. So that might be an example of where a proportionality exercise may be looked at in order to determine...
But that person would have to be within the zone.
Yes, that's right.
So I'm not... Right. So she may just be standing there by herself, is that what you mean?
She may be. We would need to
Right.
look at the specific facts
Right.
of the case. We'd need to look not in the abstract, but in the definite analysis, which is what
Yeah.
lies behind.
I can see why in those circumstances it might be oppressive to prosecute the mother, but I can't really see why the mother has stronger Article 10 or 11 rights than anybody else in seeking to...
No, I'm not suggesting that, but I was being asked...
Wouldn't that have to be the proportionality
Yes, that's right.
balance?
Yes.
Well, why is the balance of the conflicting rights struck in a different way for the mother than it would be for a member of the public?
I suppose when one looks at the connection that the mother would have with the daughter, and there may be an Article 8 issue in and around that particular relationship, but I was asked the question as to whether or not we could look at examples where the proportionality exercise would be carried out, and that's just one example that throws up some issues that indeed were looked at in the debate before the Northern Ireland Assembly. Another example is, for example, someone is charged with influencing a person who is just attending the premises to obtain information about abortion services for a friend or relative, that person being a protected person within the meaning of Clause 8. It may be that prosecution and conviction would be disproportionate to protect the rights of the friend.
Sorry, I
or
didn't
relative.
catch that. Could you just repeat it?
I'm afraid I am having difficulty hearing as well.
All right. So the other example that I was drawing on was somebody who's charged, for example, with influencing a person who is simply attending the premises to obtain information about abortion services for a friend or relative, that person being a protected person within the meaning of Clause 3. It may be that in that case, prosecution and conviction would be disproportionate to protect the rights of the friend or relative. Another example that I thought about was the uninvited, distraught parent of a teenage girl who may follow her to the protected premises and seek to persuade her not to undergo an abortion.
Is that the first example, though? Is that the same? Isn't that an overlap with the first example?
It is an overlap, but I'm particularly focusing on the parent of a teenage girl and the particular acute circumstances that may flow from the age of the young woman and the state that she was in and the relationship, the parental relationship that exists in that particular context. And so it may be that such a parent would seek to persuade the distraught teenager not to undergo an abortion, and it may be in that situation that a Clause 5.2a conviction may not be appropriate or proportionate in that particular familial setting. Or one other last example that I had envisaged was the parent of a teenage daughter who may have told her local church or community group or social media, who then in number, whether at the parent's suggestion or otherwise, attended the protected premises to pray for the soul of the child. Conviction of those persons may be proportionate, but again, we're looking at the need for a fact-specific exercise to be carried out consistent with the approach of the European Court of Human Rights.
But that raises the whole issue, perhaps, of those engaging on a vigil anyway, an entirely peaceful vigil, and not engaging in what might otherwise be regarded as reprehensible behaviour. And to what extent it is appropriate for that whole cohort of individuals to be considered alongside those who have been recorded as engaging in the much more offensive.
So I think that was the point. That was the point that Mr. McLennan was focusing on yesterday.
Yes.
And I do wonder about the making a difference between silent attendance outside the clinic as opposed to one where there's overt, violent type of conduct that we could characterise it as. And what I said yesterday about that was it may very well be that silent vigil or silent prayer is just as concerning, just as worrying, just as psychologically damaging to a young woman attending at the clinic as would those shouting abuse at her. It is reasonable to say that we shouldn't essentially put that in a separate character and say that will always be something that should be treated differently. I think it very much depends on the facts of the case. And it may very well be, as I say, that that sort of protest, engaging in that way, silent prayer, almost standing in judgment, is far more damaging to the young woman than hurling names and abuse at her.
Well, this issue was discussed by the High Court of Australia.
Yes.
It might be useful if we at some point were taken to discussions of these issues by other common law jurisdictions. It's all very well looking at European cases to do with agricultural protests or whatever, but we've got, a decision of the High Court of Australia on the very type of issue we're dealing with is obviously highly relevant.
Yes, I think my Lord makes reference to some of the cases that have been referred to in the Commission's intervention, which are particularly helpful in this context. And the Commission make reference to Club Against Edwards at paragraph 40 of their intervention, which is at the electronic folder at page number 71.
Just before we go there, might another example that occurred to me be the father of the unwanted child who seeks to influence his maybe even former partner not to go ahead. Might that be an example of where on specific facts one may consider one would have to carry out a proportionality assessment of a prosecution in any event?
Yes, that's so. I agree with that, my Lord. So,
before you move on, forgive me. You've identified a number of exceptional situations in which you say that the question of proportionality would have to be addressed. What would be the judicial machinery by which that issue should be addressed?
So there would be a series of prosecutorial decision-making situations that would arise following on the situation being brought to the attention of the prosecuting authorities. And to give the example of Scotland, the situation that would follow would be the prosecution would receive a report from the police explaining the circumstances in which an arrest or a report has been made, and the prosecuting authorities in Scotland, exercising the prosecution code, would look at the nature of the offence and exercise a proportionality assessment in determining whether or not to take a prosecution. They would look at the whole facts and circumstances of the case and determine, as a prosecution authority, whether or not the case merited a prosecution, looking at not only the facts but also balancing the competing rights that would require to be considered under the Convention.
So is it simply a matter for the prosecution?
Thereafter, when the case if there's a decision to prosecute and the case is taken to the court, depending on the facts and circumstances of the case, the court may look at the proportionality issues in terms of Articles 8, 10 and 11 before conviction, or on appeal look at the question of the relevant proportionality in terms of the penalties imposed by the court at first instance. So I see it as an exercise that would be looked at not only pre-prosecution but during the course of any trial that would be brought before the courts by the judicial.
So in those circumstances, would it be appropriate for there to be an application on grounds of abuse of process?
Well, I think my Lord's touching on some of the issues that were raised in Kukurian and a subsequent case that's been before the High Court, I think Brown, which looked at that too.
Brown seems to rule out.
It does. Yes, it rules. I think the particular issue of stay was ruled out in Brown. And I think in Kukurian, the court looked at 3 different situations where there may or may not be an examination of competing rights under the Convention before a determination was made as to whether there should be a conviction or not. And I'm going to come on and look at whether those 3 particular identified bases that were highlighted in Kukurian by the appeal court, which were whether there's a Ziegler ground, whether the ingredients of the offence are such that it merits conviction, and the conviction of itself demonstrably shows that there need be no concern over competing convention rights because the ingredients of the offence are such that it rules out that balancing exercise. Or thirdly, there might be a case in which the balancing exercise is carried out by the court before a decision is made to convict. So Kukurian, I think, identifies 3 separate ways in which these issues may or may not be considered.
Kukurian was a case where there was a provision in the offence for requiring the absence of a lawful excuse.
Yes, because it was an aggravated assault, and a particular type of assault, aggravated assault, included some...
Aggravated trespass, I think.
Yes, aggravated trespass, I'm so sorry. It was an aggravated trespass, and it was the particular content of that crime that meant that the court concluded there was no need to do the Ziegler assessment or any other proportionality assessment.
It may be that the question that we have to address has to be considered whether or not there is a provision for lawful excuse. And if it can't be by way of an abusive process application, I'm puzzled as to how the matter could be brought before the court, a decision.
So in a situation where hope I'm not misunderstanding, my Lord. My Lord is saying that there may be a situation where there's no reasonable excuse defence and the ingredients of the offence are such that demonstrably by committing that offence there is plainly no question of the necessary balancing exercise to be done by reference to competing rights. What's to be done in that situation? Is that
in one of these exceptional situations
yes.
that you've identified, how is it to be brought before the court? Is it to be a judicial review of the decision to prosecute? Or is it to be an abusive process application? Or is there some other machinery by which you can...
Well, I would have thought that the way in which that it's looked at is the way in which the court in Kukurian identified as in terms of the third type of analysis, which is that it would have to be a lawful conviction, and the court would have to look at the competing rights in order to determine whether or not the conviction that's returned is sound.
I can see that in a Couturian case, but it doesn't work in a non-Couturian case where there's no provision in the offence.
Well, I would have thought that even when there's no such provision within the offence itself, that the court would be bound to ensure that the convention rights of the accused person are considered, and that in the round, in the decision-making process that would return whether or not there's a conviction or not, the convention rights of an accused person would require to be considered.
Are you really saying that a court firstly has to look at whether Article 10 is engaged, and then whether there's been an interference, and whether a conviction is proportionate? And of course, under Article 10 jurisprudence, there have to be reasons given for any interference.
So I think that's right, my lady.
But it is something of a freestanding type analysis then, convention-wise, as opposed to looking at it within the prism of lawful excuse, which is...
Yes. I think that's what, if I read Lee Brown correctly, that was the approach of the court in Lee Brown. And so the defence, I suppose, could take a plea that the conviction would be unlawful under Section 6 of the Human Rights Act, or the court as a public authority could ask itself the question, and my position is that's exactly what the court should do, is to ask the question. And I think what's interesting to note is that in Couturian, the court looked at a number of cases where there was no need to address the balancing exercise. And one particular one was a case of Gifford against Her Majesty's Advocate. And that was a case that my Lord Reid and Lord Carloway sat on in the High Court of Justiciary, sitting as the Court of Appeal in Scotland. And in that case, there was a conviction for breach of the peace returned, which by itself, in terms of the definition of breach of the peace, meant that there could never have been the need for the court to carry out the balancing exercise that's required in terms of Article 8, 10 and 11, because the nature of the breach of the peace was such that it was violent and it caused real disturbance and concerned the public. So that is a sort of case where the ingredients of the offence itself means that the court wouldn't be bound to look at these competing issues. And indeed, the appeal in Gifford was against the fact that the sheriff sitting at first instance hadn't given directions for the jury to do that balancing exercise. But the Court of Appeal said there was no need for that because of the nature of the offence of itself. And indeed, in doing so, drew on the European Court of Human Rights Authority of Lucas, which is referred to in the case of Kudryavicius, if I can pronounce it correctly. Kudryavicius.
Couturian.
Yes.
Sounds like a sneeze.
Yes. Okay, thank you very much, my lord.
No, I thought you were referring to the Kudryavicius.
Kudryavicius.
Oh, beg your pardon.
Yes.
K-U-D.
Another difficult one.
Yes, it was. Yes. So,
you rely on this ability of the magistrates' court to carry out a proportionality assessment at that stage. My understanding is that you rely on that to say that we don't have to be concerned with whether, on its face, this legislation is within competence, because even if it might look as if it is trying to set a proportionality assessment for all stages subsequent in its implementation, it's not doing that. So we can assume that it's compliant because whatever it says, there will have to be a proportionality assessment at each stage.
yes.
My difficulty with that is, I'm not sure how that's consistent with the UNCRC case, which does seem to say you do have to look at what the legislation says, because that's the task given to this court under a reference, and not just pass it down to the next stage. And also, if this court doesn't make any assessment of the proportionality, what is it that stops a subsequent defendant in an unexceptional case, a protester saying, you must carry out, magistrate, a proportionality exercise, and I say that this whole legislation is disproportionate, or 100 metres is disproportionate, or there should have been a designated zone. How many of the decisions that would otherwise be going into a proportionality assessment are made by the legislation, do you say, so that it's only in exceptional cases that the magistrate might come to the conclusion that even though the ingredients as they look on the statute are made out, that it's nonetheless not proportionate to convict?
No, I'm not sure if I would say it would be an exceptional case. All that I would say is that what's required is the court to undertake what's necessary in terms of their obligations under the Human Rights Act, and to consider whether or not the interference that has been undergone by virtue of the prosecution is an interference that's justified. There's a distinction, a very important distinction to draw between this particular case and the UNCRC case. And I think yesterday I was making the point that in the UNCRC case, the issue was the question of an impugned provision clearly relating to a reserved matter. We are not dealing with this issue here. This is not clearly a reserved matter. This is a situation where the Northern Ireland Assembly have brought forward a statutory offence in respect of which the terms are clear, which is if you are in a safe zone, which is properly delineated under reference to the way in which the zone has been constructed and approved, and you do certain acts, you will be exposed to the possibility of criminal prosecution. And it might be that you have a defence to that, and the defence will be, as I understand the point my lady's making, that there's been an unlawful interference with the protester rights, and the question is for the court, has there been an interference that's not justified in law? And I have to say that in many cases, that's just the sort of exercise that is carried out by the courts in these types of cases.
So you say that even in a case which appears on its face to fall absolutely within the terms of the legislation, every magistrate would have to deal with a defence raised by the protester to say this legislation is incompatible with the convention, 100 metres is too large an area, the wording of the legislation is too broad.
Well, one would have thought that the terms of the legislation are clear, and that the issue would simply be the question of the proportionality of the interference. The legislation on the face of it is clear. If you go into a zone that's delineated and you do certain acts, you will be exposed to the possibility of a prosecution. There may be some circumstances where the proportionality exercise that's carried out results in the decision being made that it wasn't a necessary or justified interference. But there will be circumstances where the actions of the protester will contain such an ingredient and be of such a nature that proportionality exercise doesn't need to be carried out. And that's in line with what the case of Gifford has demonstrated, and in line with authority tracing back to Lucas that I referred to.
I find it very difficult that to say on the one hand that if you're asking us to say that this bill is compliant, to then say, oh well, in every case this issue has to be looked at again, potentially, on the particular facts. I thought your submission would be along the lines that in almost all cases, once this has been decided it's convention compliant, there's no need to look at that. It would be in rare exceptional cases where one would have to consider particularly odd facts that would require a proportionality analysis. Again, otherwise it would seem to me you're throwing everything down the line and just saying, well, you can pass this as compliant with the convention, because it's all, every case has got to be looked at again. That can't be your submission, is it, or is it?
Well, my position is that the legislation, I think my first position was the legislation is clear. If you do certain acts as set down by Clause 5, you will be exposed to a prosecution. And it's very easy to identify where that exposure lies because it's within a delineated zone, and the nature of the acts that bring you within the ambit of a prosecution are set down clearly in terms of the legislation.
But isn't our task to decide whether, clear as it is compliant with the convention? But the clear boundary, the balance that the legislation appears to have struck, is the correct balance in almost all cases.
Well, that is my fundamental position, and I think I made that clear yesterday. But there may be cases in which the balancing exercise in terms of the competing rights have to be carried out. You can't exclude that absolutely.
No, but it's the extent of the cases that you argue would fall within that. I mean, you're not suggesting, are you, that somebody who is right bang in the centre of this bill, that is somebody who is standing within the 100 metres and is intending or recklessly influencing a person going into the clinic, are you suggesting that that person, when charged and brought before the court, is able to say, well, I'm going to raise a proportionality defence in any event here because my circumstances are peculiar?
Well, I think that each case has to be decided on its facts, and the point that the cases from Europe make is that you can't deal with these issues in abstract, but there'll be very obvious examples, just as in the breach of the peace case, where the circumstances are such that the offence demonstrably means that there should be no balancing exercise carried out in terms of competing rights, because the circumstances of the case are so obvious that the conviction flows. So I think I have said from the outset that this is a challenge not in the same way that the challenge was raised in the UNCRC case. It's something very different, and the test is whether or not I'll just get the actual wording again. Whether the clause is or is almost always incompatible with convention rights. And I think
someone in the position that my Lord or Borough says, someone is 90 metres from the clinic and they are protesting and trying to influence and holding up placards, and they're prosecuted in the magistrate's court, and they say, I have a proportionality defence because it would only be proportionate to stop protesters being 60 metres away from the clinic, and to try and stop me when I was 90 metres away from the clinic was disproportionate interference with my right to protest. Now, in that example, do you say that the magistrate has to decide, is the 100-metre limit proportionate, or do you say that is decided by the legislation?
I say that in that particular example it's decided by the legislation, because it's clear when one looks at the way in which the legislation has been passed and the evidence base for that the decision has been made by the legislature that that should be the appropriate extent of the zone, and and that the decision of the legislature is sound because of the way in which the issues were examined before the Assembly and the evidence base that was put before the Assembly from the number of relevant bodies that gave evidence and the information that was made available to those voting on the bill. So the terms of the legislation itself, if you were to look at, for example, where it is that the line is drawn, is very obviously legislation that's been passed, and it's legislation that conforms with the necessary convention issues that were considered by the Assembly at the time that the legislation was passed. The Assembly looked at the competing rights that were before it. The Assembly looked at Article 8, 10 and 11, and the Assembly was informed about all the different types of protests and the areas in which these were carried out in connection with abortion zones, and came to the conclusion that in the legislation the 100-metre line should be drawn. Other legislators have looked at different areas. We've looked at 150 metres. But that's not to say that that legislation is of itself challengeable in terms of convention issues.
But may I ask about the extent of the zone? Because you've mentioned 100 metres. We know that it can be extended by a further 150 metres,
Yes.
Making a total of 250 metres simply on request. How is the proportionality of that to be assessed in the context of the submissions that you're making, or is that something that would not be routinely considered in the exercise that you're describing to us?
Well, I suppose that we go back to the bill and the way in which the exercise has been identified as the situation in which the application for the zone requires to be made. Almost always it will be a public authority who's making the application to the health department for the particular zone that's necessary in their case, and they are bound by their responsibilities under the Human Rights Act to act in accordance with that, and one would therefore be legitimately entitled to say the exercise that they carry out will take on board all the necessary and relevant considerations under the competing rights that different people have for accessing or being near these clinics. So first and foremost, the application will be made by a public authority with the duties that they have a responsibility for under the human rights legislation, and it will be made to the health department, who similarly are a public authority. So the originating decision as to the circumstances in which the area is delineated is one that we can reasonably say will be sound under the convention. And thereafter, we know that the basis on which the legislature have passed the legislation has been one in respect of which competing rights under the convention have been looked at, and the legislature have identified the relevant zones. So
one can assume, as I understand your submission, that whether it's a public authority or not, when the request is made,
yes,
the decision whether or not to accede to it will have been made by a public authority.
So the analysis as to the need for the zone and the area of the zone will have been made in almost all cases by a public authority.
And that will itself have involved a proportionality
Absolutely.
assessment.
I think I made those submissions yesterday.
But this, sorry.
Can I ask you, it's really pursuing Lord Jones's point about how procedurally one deals with these issues. If we just to talk about something that at least you and two members of the court are familiar with, if we think about this arising in Scotland, if this were a Scottish bill for the moment, and then we can look at how it might work elsewhere. In Scotland, if the accused wanted to raise in his defence that there was a breach of his convention, that to convict him would be a breach of his convention rights, then he would have to lodge a devolution minute, wouldn't he? And what then happens? How is that devolution minute then processed?
Well, he would raise the issue within the proceedings, and the devolution issue would be considered at first instance, and thereafter, if convicted and not dealt with appropriately at first instance, entitled to appeal.
Yeah. Now, at first instance, would it be dealt with, or could it be dealt with, as a preliminary point
Yes.
Prior to the trial, or would it necessarily be dealt with at trial, or is it discretion?
So it could be either, but in this particular situation it might be that the judge determining the devolution minute would prefer to hear the evidence and to determine whether or not on the evidence that there was an actual breach. And often issues, devolution issues are left over to the end of a trial, such as, for example, where there's been a delay in proceedings and there's a question as to whether or not the trial has been fair because of the absence of a certain piece of evidence. Yeah. Often it's not possible to make a decision on that issue until the judge has been properly informed as to all of the evidence available in the case and the impact of the evidence that's missing. So it could be both.
If Ziegler is correct, then it seems to envisage that a great deal of evidence might be led, for example, about the reasons why people protest about abortion, the strength of feelings that the accused has about it, the level of his or her commitment to the cause, and so forth. Or, in other cases it might be, or for example, an examination of the history of Bristol's involvement in the slave trade, or whatever it is, or Glasgow's involvement in the slave trade, whatever it is. So you could have a substantial body of evidence being led in support of this devolution minute. So, would it be possible for the judge, or the sheriff, if it's in the sheriff court, to deal with it on the basis of taking the case as put at its highest, without having to hear the evidence about it, or would he have to, if need be, spend several days hearing evidence, which I suppose he could do at a separate hearing before the trial, could he?
I suppose the first thing that the judge hearing the matter would be concerned with is to understand what the competing rights were in the case. And the legislation has been brought into place in order to protect the Article 8 rights of a woman who is exercising their personal choice to have an abortion. And the question that would be asked is, well, are the convention rights actually engaged of the accused? Is Article 9, 10 and 11 actually engaged? And are they engaged in circumstances where the action by the accused is simply to target a woman going to an abortion clinic to get her to change her mind about having abortion? Is that actually an issue that falls under Articles 9, 10 and 11? So the question would be, are the convention rights of the accused engaged, first and foremost? I think I will come on a little later to really question that in the circumstances that we're dealing with here.
Yeah.
But thereafter, the exercise that the trial judge would be looking at is just to examine the competing rights and determining whether or not there's been a lawful or unlawful interference. I'm not sure that we would need to have all of the exercise carried out that my lords referred to in terms of looking at the evidence, looking at the history of abortion campaigns and the right of somebody to challenge the law in and around the legality of abortion. That's something different to the issue at large in the trials that would be before the court. They would be about the decision to enter a safe access zone and to conduct themselves in a particular way that may or may not engage their rights under the convention.
So am I right in understanding that your response is effectively that the judge, in order to balance the competing interests, insofar as there are competing interests, would have to hear the evidence, but he could exercise appropriate controls over the scope of the evidence led? So if a point were taken and there were a devolution minute lodged, effectively it would be dealt with at the trial. It's really what you're expecting to happen.
Yeah, so, but my point is it could either be dealt with before or after the trial, and it might be, for example, that on an agreed set of facts, the trial judge could decide, well, I'll hear this issue on an agreed set of facts without the need to lead evidence.
Yes, yes. And just say for the sake of argument, it wasn't a summary offence, but it was one which in England might be triable either way, or in Scotland would be on indictment. Proportionality is an issue of law, whether the interference with the convention right is proportionate or not. So it's not an issue that could be determined by a jury, but as we've explained, it might require evidence to be heard. So how would it? There would again be a devolution minute. How would it be handled in the course of the of proceedings on indictment?
So I think I'm not. I'm just trying to remember whether or not it would be a devolution minute or a compatibility issue.
Oh yes.
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 I think it's compatibility issues now.
Yes, I'm afraid there are some. After my time, it didn't.
Yes, and I think that if it's on indictment, and there's it would be an issue heard in the High Court, or at sheriff and jury level. Lord Carloway will know this better than me, my lord, but the situation as I understand it is if it's a trial in the High Court, the decision will be made by a judge at the High Court level, and that is appealable to the High Court as a compatibility issue. And on a compatibility issue, there is a right of appeal to the Supreme Court over the issue. But if the case is tried at sheriff and jury level, I think that there's not a right of appeal to the there's a possibility that the case can be referred to the Court of Appeal, and a possibility of a compatibility issue being appealed to the Supreme Court. A right to appeal to the Supreme Court on a compatibility issue only arises where there's been a decision of 3 members of the appeal court on the matter. I think I'm right, Lord
in the High
Carloway
Court, would the issue be again dealt with? In practice, would you expect the issue to be dealt with as part of a trial rather than pre-trial?
Well, it could be both, but the best way to deal with it would be pre-trial, I would have thought.
Well, if the Crown were faced with an intimation that the defence were going to lead evidence of the nature of the disproportionality of the prosecution or whatever, then it would probably actually be the Crown that took objection, took a preliminary issue minute in relation to the evidence, and it would be heard in the High Court at a preliminary hearing, or in the Sheriff Court at a first diet, and it would be a matter for the Sheriff or the Judge to decide how that was going to be dealt with, whether any evidence was required or not. But on the face of things, and just following on from what the President is saying, this is not on the face of it a matter which you could ever leave to a jury. That's the issue.
Yes.
But from what you're saying, it might be. And if so, how do they resolve it?
Well, yes. I mean, it can't be an issue for a jury, can it? Because juries don't decide issues of law.
That's what I didn't mean that it would be a compatibility issue that would either be decided pre-trial on the basis of an agreed set of facts or after evidence had been heard, but it would be by the judge. I wasn't suggesting it would be by the jury.
Yes.
But you are anticipating that in other jurisdictions it would be dealt with by the lay magistracy.
Yes, I mean, I'm not sure what the precise
I'm
procedure
proposing
is.
to put the same questions in
Yes.
relation to Northern Ireland and England and Wales. So when I asked you about summary procedure and I spoke about devolution minutes, was that also a mistake on my part? It should
I think
be
they are
talking about compatibility issues.
Yes, so I can't remember when it was that the law changed, but it changed in order to ensure that the compatibility issues would be referred from the High Court here.
Yes.
And I think that was to resolve a lot of issues over backlogs of challenges and unnecessary administrative issues that were being raised.
Yes.
But there is a process whereby compatibility issues can be referred to the High Court
Yes.
from sheriff level, as I recall. I'll get the precise statutory provisions. I was being shown the provisions here, but I can give the precise framework in a written document to the court.
Yes, and the compatibility issue would always have to be decided by a judge, wouldn't it? I mean,
Absolutely. I was never suggesting that the legal issue would be one determined by a jury, and that's why I used the example of the question of a fair trial in the absence, in a circumstance of delay and in the absence of a particular piece of evidence. The judge often would deal with a delay challenge post the hearing of all the evidence.
Yes, yes.
Miles, do you see this process being accommodated within the existing system? Is it going to cause real practical problems or not?
No, I don't see. It's not. We wouldn't need to develop a new procedure. The procedure is there in order to deal with.
In terms of the time and the complexity involved, would that create problems?
It wouldn't, because of the way in which our legislative framework deals with compatibility issues. And there was, I'm not sure of the date of it, there was a very recent analysis of all of these issues undertaken, I think, by Lord Carloway and indeed Lord Reid in a report, and I'll be able to get all of the background to that and the existing legal framework produced in a document relatively quickly.
Now, of course, Scotland has, in Scotland, this is all based on statute. It's Scotland Act 2012 that establishes compatibility issues, and the rules of the criminal courts and rules of procedure lay down how these things are dealt with on a day-to-day basis. What we don't know at the moment is whether there are any analogous rules for Northern Ireland.
Yes.
Yeah.
And I suppose overriding everything in terms of the decision to prosecute would be the question of the public interest. Yeah. Is it in the public interest to prosecute in a particular case? I think the authority that I was referring to was a case of Lashmankin at page 1055, paragraph 430, and that is a case in which the court, the Strasbourg court, indicated that which I'm saying, which is any case requires to be examined on its facts, and review of the law in practice should not be done in the abstract. So I say that it cannot be said at this stage of an ab ante challenge to the legislative competence of Clause 5.2a that it could never operate compatibly with convention rights. The submission in my written case at paragraph 12 and also paragraph 16 are in the context of legislative competence, and there may well be individual cases where a clause 5.2 offence would be disproportionate, but these would be cases that would fall out with the norm, as I would see it, because the nature of the offence is such that it's drawn clearly and it's very obvious the circumstances in which an individual is exposed to the possibility of prosecution. And I was going to deal at this stage with the justice intervention, and the justice intervention is particularly at paragraph 2 of the electronic folder at page 40, raises the issue of the way in which the advocate, the Attorney General, has dealt with the issue of the convention. Justice argues that they wrongly conflate the question of whether a provision is incompatible with Articles 9, 10 and 11 per se with the question of proportionality of any resulting restriction on a person's Article 9, 10 and 11 rights. This is consistent, I say, with my submissions that the proper approach for an ab ante convention challenge is to ask whether the provision will always or almost always be incompatible with convention rights. Justice addressed the restriction by submitting, as we understand their position, that a conviction under clause 5.2a is to be assessed on the particular facts. We agree with that, and therefore the broad proposition of justice at paragraph 4, that the absence of a lawful excuse provision in clause 5.2a does not mean that it's outside the competence of the Assembly. The analysis in the case of Ziegler and Kukurian, and whether Kukurian was correctly decided, is, I suggest, best left for a future case, although I would make a number of few brief observations at this stage. In relation to protest offences, arrest, prosecution, conviction and sentence are restrictions within Articles 10 and 11. And in that regard, I would refer to Ziegler at paragraph 57, electronic folder page 483, and Kudrycius against Lithuania, where it's cited there. So essentially, the prosecutor, the court, will require, the prosecutor and the court will require to assess in any given case whether prosecution and conviction would be proportionate. I touched on the Scottish position, but would simply say a little bit more about it in this way. In Scotland, the prosecutor requires to apply the Scottish Prosecution Code. If satisfied that an offence has occurred and there's sufficient evidence in law, the prosecutor will decide what, if any, prosecutorial action is in the public interest. And factors that are taken account of by the prosecutor would include the nature and impact of the offending behaviour, including on the complainer, the personal circumstances of an accused, and any risk of reoffending. Cases would and probably should be taken at their lowest competent court unless there's good reason to do otherwise. And the code, the prosecution code in Scotland, reflects the underlying principle that the response of the justice system should be proportionate. And there are also alternatives to prosecution. Public order cases engaging Articles 10 and 11 rights might be considered in three broad categories, and I note that they may not necessarily be distinct. And in saying this, I draw on the case of Kukurian at paragraph 57 in the electronic folder at page 442, where it cites James against the DPP, and two categories of public order offences at paragraph 58 and paragraph 61, citing the case of Gifford that I've referred to, a breach of the peace case. Dealing with the Ziegler cases, I would say that these are cases where the offence is subject to a reasonable or lawful excuse exception. In this category of case, the proportionality assessment is built into the offence, and Ziegler was, of course, concerned with Section 137 of the 1980 Act, which was an offence under the Highways Act, which was subject to a lawful excuse defence, and therefore fell into the first category of public order offences. The Supreme Court there held that Section 137 should be interpreted compatibly with Articles 10 and 11 in cases where the availability of the lawful excuse defence depended on the proportionality assessment that was being made. So that's the first category. The second is where the ingredients of the offence allow themselves for the assessment of proportionality. And essentially that is in cases where once the specific ingredients had been proved, the accused conduct had gone beyond what could be regarded as reasonable in the exercise of convention rights. Here there'd be no need for the prosecution to satisfy any additional proportionality test. And as I said before, this is exemplified by the approach that was followed by the Court of Appeal in Scotland and the High Court of Justiciary in case of Gifford. Drawing on the case of Lucas, and this Scottish case is cited in Gifford, the Lord Reid, sitting along with Lord Carlyle and Lord Wheatley.
Can you give us the electronic page for Gifford?
Gifford's not in the bundle, it's referred to in the case of Kukurian, and I can provide a copy of Gifford, my lord, later today.
Where is it in Kukurian? Oh, there it is, paragraph 61.
Paragraph 61. So I think I can quickly summarise that the court in Gifford drew on the case of Lucas and other Scottish cases cited there.
Lucas was Caroline Lucas, now
That's
an MP, blocking the road to Faslane.
Faslane, that's right.
And she was convicted, I think, of a breach of the peace.
She was, yes.
And her complaint to Strasbourg was, if memory serves, dismissed as manifestly unreasonable.
Yes, that's exactly
so. Manifestly ill-founded.
Yes, that's exactly correct, my lord. And as I say, that particular case is referred to in the Trevicius case. But essentially, the case of Gifford and indeed Lucas make it clear that the Convention rights of freedom of expression and freedom of assembly do not entitle protesters to commit a breach of the peace. And that's a crime which in Scotland displays conduct which is severe enough to cause alarm to ordinary people and threatens public safety or serious disturbance to the community.
I mean, Gifford itself was about protesters who managed to close down an airport.
Aberdeen Airport.
Aberdeen Airport, and so they prevented emergency services from flying out to the oil rigs, and they prevented an air ambulance from taking a sick baby to hospital.
Yes, I think the disruption was enormous, and the distress to passengers in the airport was horrendous. So, yes. So that's the case where ingredients of the offence of themselves allow for the assessment of proportionality. And then the third group, those cases where proportionality is not built in, either through an express defence or the ingredients of the offence, but where the conviction in all these circumstances wouldn't be convention compatible, and that's particularly referred to at paragraph 70 of Kukurian.
So are you saying that this bill, if passed, is category, which category is it?
So
is it two or three?
It's 2 or 3. Because an offence under clause 5.2 may be a third category depending on the particular circumstances.
I think it is 3.
Yes.
Not make it 3.
I don't think it could be 2, given what you said.
Yes.
If I'm right, so it's 3. But Article 10 arguments are going to arise predictably in all of these cases.
Yes.
But they're dealt with in this, what's described in Kukurian as a freestanding way.
Yes.
Because Article 10 is said to be engaged.
Yes.
And a court has to look at whether the conviction, which would be an interference, is proportionate
Yes.
and reasoned. Is that what you're saying?
Yes. So that is what Kukurian was saying, and what we know is that this court has to decide the questions before it today on the basis of the law as it stands, and I don't understand there to be an outstanding challenge to the Court of Appeal decision in Kukurian. Leave to appeal was granted to this court but wasn't pursued. I don't know, I can't advance the reasons for that, but I think what's clear from the Kukurian case is that the court looked at it very carefully and relied heavily on significant jurisprudence, not only from the decision of the Court of Appeal in Scotland, but also from a decision of Lord Hughes that was very much in point. I think the case is Richardson that they quoted Lord Hughes from. So it's in my respectful submission, a case in which has looked at these issues with care and examined out the possibility of 3 different categories of cases that ensures that there is an appropriate way of dealing with the convention rights of an accused person in the criminal process where Article 10 and 11 rights are raised, depending on the nature of the offence in respect of which they're charged. So I'm just looking at the time. I hope to be a little shorter.
Yes, we've taken up a lot of your time with questions, but it seemed to us to be necessary.
Yes, thank you.
So you haven't, as it were, lost out on time. We make allowances for that.
Thank you very much, Lord. So the important point that I want to make is that, as noted in Ziegler at paragraph 59, page 484 of the electronic folder, is that determination of the proportionality of an interference with convention rights is a fact-specific inquiry that requires the evaluation of the circumstances in the individual case. And this dicta really is at the heart of my submission on legislative competence. The assessment of each case being fact-specific, it cannot be said that Clause 5.2a will operate in all or almost all cases incompatibly with convention rights, or, as formulated in McLaughlin's analysis, incompatibly in a legally significant number of cases.
You see in paragraph 60, the second sentence.
Paragraph 60 of Ziegler, my lord.
Yes.
What page, Robert?
Oh, it's page 484. It's just the next paragraph from the one we were taken to.
Yes. So there it says, in a criminal case, the prosecution has the burden of proving to the criminal standard all the facts upon which it relies to establish to the same standard that the interference with the Article 10 and 11 rights of the protesters were proportionate. If the facts are established, then a judge, as in this case, or a jury, should evaluate those facts to determine whether or not they are sure that the interference was proportionate.
Yes, so that's contrary to what we were saying earlier.
Yes. But I think that obviously Ziegler was not a Scottish case,
No.
and wasn't looking at the
The point, the principle is the same. I mean, it's saying, it's assuming that because there has to be an evaluation of the circumstances, that determining whether an interference is proportionate is something that should be determined by a jury.
Well, I think my lord was making the point that it was a legal issue.
Well, that's certainly my understanding.
Yes. And I'm just wondering the extent to which there were submissions in and around the process by which these issues would be resolved. But in Scotland, I think we've touched on the process whereby compatibility issues are raised in the trial process, and it would be that there would be a compatibility issue raised by the defence as to whether or not the prosecution in Scotland, taken by the Lord Advocate in the role as a public authority, was convention compliant.
Yeah. Yeah, thank you.
So that leads me on to a second issue of principle. This chapter of my submission overlaps with the first, and that is the question of the qualification required under the Human Rights Act on obligations imposed on a devolved legislature, and the extent to which that is qualified by the Human Rights Act requirements. Clause 5.2a requires to be read, if it is possible to do so, in a way which makes it within the legislative competence, and I refer in that respect to section 83 of the Northern Ireland Act. Because this is a convention compatibility challenge, the exercise under section 83 is undertaken by reference to section 3 of the Human Rights Act. That's reproduced in the electronic folder at page 1187. And in this regard, the case of DS against Her Majesty's Advocate is important to look at, because that's a case where there was a challenge to the process and procedure that governed the ability of an accused person to ask questions in breach of the rape shield legislation in Scotland. And it was an issue that was raised under Article 6, and a challenge as to whether or not an accused person was being granted a fair trial in the absence of an ability to ask a certain form of question. DS against Her Majesty's Advocate is at tab 5 of the authorities in the electronic folder at page 527, and I was going to refer particularly to paragraphs 22 through to 24. So the case itself starts at page 515 of the electronic folder, and the paragraph that is particularly apposite in this case is paragraph 24 on page number 527. At paragraph 24, it says that it is otherwise in the case of convention rights. The proper starting point is to construe the legislation as directed by section 3.1 of the Human Rights Act. If it passes this test, so far as the convention rights are concerned, it will be within competence. The obligation to construe a provision in an act of the Scottish Parliament, so far as it's possible to do so in a way that's compatible with the convention rights, is a strong one. The court must prefer compatibility to incompatibility. This enables it to look closely at the legislation to see if it can be explained and operated in a way that's compatible, and if it's not, how it can be construed so as to make it so. And in the same vein, the authority of Salveson against Riddle supports that approach to the section 3 of the Human Rights Act, and we make reference to Salveson against Riddle, which is at paragraph 46 in our written case, and in particular I'd refer to the authorities at tab 11, and the page in the electronic folder that's relevant for Salveson against Riddle is page 713. So, as I've already submitted, it is unlawful for a public authority to act in a way that's incompatible with a convention right. That's Section 1 of the Human Rights Act. The obligation under Section 1 doesn't apply if a public authority is required by primary legislation to act otherwise. And that's, of course, Section 6.2a, which is at page 1188 of the electronic folder. Primary legislation is defined in Section 21 of the Act, which is at page 1190 of the electronic folder, and doesn't include an Act of the Assembly. Such acts are specifically included within the definition of subordinate legislation. The Northern Ireland Department of Health is a public authority and remains under the Section 6 Human Rights Act duty, regardless of what obligations are imposed upon it by the Northern Ireland Assembly in secondary or subordinate legislation. In other words, if the Assembly's Act may provide that a public authority must do a certain act, that apparently absolute obligation is subject to the Section 6 Human Rights Act duty. And Section 1 of the Human Rights Act provides that so far as it is possible to do so, primary legislation and secondary legislation must be read and given an effect to in a way which is compatible with convention rights.
But if your argument's right, I don't see how this court could ever find that legislation referred to it by the Attorney General was incompatible, because the answer would be, well, if it's incompatible, when it comes to be applied, the public bodies applying it will have to comply with their duty under the Human Rights Act. So what is the point then of having this reference procedure?
The reference procedure applies to questions in and around, for example, legislative competence. That is whether or not a decision to pass an act by the Northern Ireland Assembly is a provision that they're allowed to pass under the devolved settlement. So there may very well be issues in and around compatibility that are referable by reference to these issues, such as whether or not there was a bill that it was competent for the Assembly to pass.
But it is competent to pass it if you're right that, I think what you're saying is that it is competent to pass it even if on its face it looks incompatible, because it will not be applied by the public bodies that appear to be tasked with applying it in accordance with its terms.
So my point of making this,
your point then.
the reason that I make reference to this particular issue is because of the challenge that was made by Mr McLennan over the statutory provisions that said that the Department of Health must register the abortion service and it must register the safe zone. The point is that within the ambit of the responsibilities of the Department of Health, they have to act compatibly with convention rights.
Don't we have to address this legislation and our task under the reference on the assumption that they will do what they're required by the legislation to do?
I think it's what they're required by law to do. So by law, the subordinate legislation has to be read in accordance with...
So suppose the legislation said it was the safe zone is within 1 mile, say, of a clinic, and the attorney referred it and said, well, 1 mile is clearly disproportionate, it's clearly incompatible. You would say, no, it is compatible because, in fact, the Department of Health will never make a safe zone because that would always be disproportionate.
But would respectfully say, my lady, these are issues that are being conflated. The point is the legislation has been passed by the Assembly on the basis of a proper assessment of the evidence base before it, which was that there were competing rights that required to be protected in the sense that the Article 8 rights of individual women were being challenged day and day.
I understand those arguments, but...
And so the legislation itself is compatible within the bounds in which public authorities have to adhere to the responsibilities under the legislation. They have to take on their duties under the Human Rights Act, and for subordinate legislation, they have to do that so far as possible to do so in a way that's compatible with convention rights. So if one's looking at the question of the competence of this bill and the way in which it's to be operated, one has to understand the legislative framework that the public authorities responsible for delivering it are operating under, and they too are required to ensure that they operate in a way that's convention compliant. They've got to read into the provisions words that make it appropriate for them to act in a lawful way. And I don't see any difficulty with that. This court is doing a different exercise. This court is deciding whether or not, on the face of the legislation, it's competent for the Assembly to have passed it. It's not obviously out with competence because it doesn't deal with a reserved matter. And this is a challenge for an ab ante issue, such as being raised by the Attorney General from Northern Ireland, is that in a challenge of legislation that's not yet passed, if it's dealing with convention compliance, it is a very difficult issue to decide ab ante, and it's a very high threshold to cross for this court to say it's incompatible. And so if indeed the public authority who are looking at the delineation of the zone identify that a 1 mile limit is appropriate, and that on the face of it is incompatible with section 3, yes, yeah. That would be incompatible with the Convention and can't be saved by Section 3, reading it with Section 6, because it wouldn't be possible to give the legislation effect in a way that's compatible with Convention rights. But it is the point that we're making here is this is an ab ante challenge, and the issues before the court are ones that are very clear, which is it the case that on the legislation that's before it, that this will be a piece of legislation that will mean, in all or most cases, it won't be convention compliant. You just simply can't say that. That's at the heart of our submission.
But I share Lady Rose's concern that you seem to be having your cake and eating it, because you are telling us that it's compliant because there is always this fallback of proportionality assessment. At one point, I think you said, but that would fall, those sort of situations will be outside the norm. In other words, they will be exceptional. And I can understand that argument. But then you seem to backtrack from that and say, oh no, it's not just exceptional cases. And that makes me feel you're having your cake and eating it.
Well, I wonder if it's the use of the word exceptional. I don't know if we... I don't think
outside the norm, which is at one point what you said, is what I would call exceptional.
Well, I think it was Lady Rose's word. She used the word exceptional, and I had used the word outside the norm.
So is that your submission?
That's what I've said all along, my Lord, yes.
That it is only exceptional cases outside the norm where one would fall back to an individual assessment of proportionality by the public authorities?
I would say that on the reading of the legislation, that must be so.
Right, thank you.
But there would be a notional exercise they'd have to go through in every case, presumably, just to satisfy themselves. No, it's a routine case. there is nothing more that needs to be done here.
That's the import of the responsibilities on the court as a public authority in every case.
Yes, every case that at least ask themselves the question.
Yes.
But it would admit of a very simple answer.
Yes.
in the majority of cases.
Yes.
The difficulty, though, with it being a simple answer is it an answer which is challengeable by way of judicial review of the clinic, assuming it's a public body, and then the Department of Health? Because my concern is that the way you see this rolling out, this legislation, may be very different from what the Assembly envisaged, because you seem to see the clinic, assuming it's a public body, making a proportionality assessment in deciding whether to notify the clinic to get a safe zone. Would you say that if they decide to do that, that is a question, that a decision that can be challenged by way of judicial review by a body that objects to that? Then it goes to the Department of Health. They look at the application. You say they have to carry out a proportionality assessment as to whether to list it. Again, is that decision capable of judicial review? If it's listed, then every time there's someone prosecuted, the magistrate has to carry out a proportionality assessment with the consequences that my Lord Reid suggested. Now, is that what you see happening? Because if it is, it seems to me that the people who voted for this may well say, no, we've made the decision on proportionality in this legislation, and the intention is, or the purpose of it is, that it should be quite automatic because we've done that bit, and it shouldn't be open to challenge at each of these lower stages. Otherwise, these zones are never going to be established.
Well, the public authorities who are making these decisions have obligations to make their decisions by reference to their duties under human rights legislation, and every decision of a public authority has to be compliant with the human rights legislation. And there is you no doubt refer to the possibility of judicial review of decisions of bodies who decide that there should be a safe access zone because it might be, for example, there's absolutely no evidence that it's needed.
Right, so then it's the role of this court to say that because there are going to be all those decisions which are capable of judicial review in individual circumstances, then the legislation is compatible and we don't need to say anything about our view of whether it's on its face looks proportionate, or is the role of this court to say our view is that it is proportionate, assuming it is intended to operate as the attorney suggests, and give some guidance to how these decisions should be made?
Well, obviously it's a matter for this court, but in my submission, the decision from the Assembly to pass this legislation was based on sound evidence from the committees that they were referred to and interested bodies, and very compelling evidence about the dreadful circumstances that some women were experiencing accessing abortion clinics. So the decision was that in certain circumstances, a safe zone should be established. So there was an evidence base for the Assembly to pass their legislation, and there would have to be an evidence base for each clinic to make the request to the health department. And these will be, for the most part, public bodies who have responsibilities to act in compliance with the Convention. So within the way in which the safe access zone is set up, there will be, and there will have to have been, decisions made by public authorities on the merits of the zone and the extent of the zone. There have to have been. That must underpin the decision for the Department of Health to put the to record the request and to publish the fact of the zone's existence. It can't work any other way.
I think the point, though, that Lady Rose raises is related to the mandatory language within the bill, which I would have thought highlights the fact that there was an anticipation that there would be, upon application, a safe access zone made. And the other point is that there are numerous public authorities engaged in Northern Ireland in terms of provision of these services. So what on your case, what could happen is that different public authorities take different views. How does that square with a bespoke piece of legislation on safe access zones, which is what this is?
Well, there has to be a method by which the zones are created, and there has to be a process by which they're set up that's lawful. And albeit the language in the section that we're looking at is that they shall record the zone and publish it, the Department of Health. It's only appropriate to point out that the legislation that exists under the Human Rights Act requires an interpretation of subordinate legislation in the way that it does. And we've looked at DS, and we've looked at Salveson against Riddle. And it might be that there are problems in and around the creation of the safe zone and challenges over its very existence. But once it's in place, and in place lawfully, the legislation is clear as to what would be wrong for an individual to go into that place and to act in a particular way. There has to be a process that means that the zone comes into existence, and it has to be lawful. There are decisions of public authorities that are challengeable in and around all of that. But that doesn't mean to say that the terms of the clause that has set down the criminal provision that we're looking at is incompatible and one that's not competent for the Assembly to have passed in this ab ante challenge.
We've seen in this court in other contexts how in Northern Ireland judicial review can be employed to paralyse public services. And I think there's a risk that we could render this legislation a dead letter if we effectively say that everything is up for grabs.
Well, I suppose then that it's really for this court, and the court can reject my position on the need for a proportionality assessment, of course, and adopt the approach that the Human Rights Commission have adopted in their submission in relation to the legislation of itself, having cast the correct, proportionate assessment. I think if we look at the Commission's position at paragraph 25 of their intervention, which is at page 67 of the electronic folder. The Commission's position is that, first of all, on page 67, 25A, the establishment and size of safe access zones are matters that will be determined on a case-by-case basis in order to ensure compatibility with convention rights. Duration will be subject to a continuing assessment for compliance with ECHR rights pursuant to the Section 1 Human Rights Act 1998 duty. This for the reasons set out above. The AGNI's case is therefore wrong on these issues. The offence contained within Clause 5.2a of the Bill contains no reasonable excuse defence. In the specific circumstances of the Bill, the balance between competing rights has been struck by the Assembly. No further proportionate analysis, whether by constables exercising powers under Clause 6 of the Bill, prosecuting authorities or the courts, is permitted. Alternatively, the Bill would still be compatible with the ECHR if a further proportionality analysis was necessary. And I think the first position of the Commission is that the competing rights have been struck by the Assembly in the formulation of the provision. And that's certainly consistent with, a legal analysis underpins that approach is certainly consistent with the way in which the court looked at issues in the Kukurian case.
Well, if that's right, that applies to all cases?
Yeah.
And does that not rather make Mr McGlennan's point in terms of the ab ante challenge test?
Yes, well, that's why I don't agree with it.
Right.
And that's why I do see that they have an alternative position.
The alternative position is your position.
Yes, absolutely.
But isn't there an alternative position, which is their position, that it is struck by the legislation, but that, unlike what the attorney says, it is proportionate?
Yes, so that, well, I think what was being said is that, well, that's right. The point that was being made by the attorney was that it wasn't proportionate, but underpinning all of the submissions that I am making and the Commission and indeed Justice is that it is proportionate. And what the Assembly's done is...
Is it proportionate only because you say there are all these other levels at which this assessment will be carried out, or do you also say, even if the attorney is right that the legislation means what it appears to say and it's supposed to be an automatic notification and listing and creation of the zone, that it nonetheless is the balance has been struck by the legislature
So I think
in the right place?
So I think if you read our written submission, we have approached it on that way. But I think my position today is that there would be, in some cases, the need for proportionality assessment. And I think I'm just repeating myself now about the stage at which this issue has been brought before the court, which is ab ante, makes it difficult. And it's a very high hurdle that has to be crossed before the decision is made that it's not within the competence of the Assembly. So my position, though, is that there's nothing in this bill that can qualify the application of the Human Rights Act, and it requires to be read and applied in a manner that's consistent with convention rights. The practical result being that the establishment of a safe access zone and the associated penalties is not automatic. By comparison, I point out the attorney's position at paragraph 61 at page 46 of the notes of his written case, which relates to 4 features of the bill. The fourth being that the restrictions take effect automatically by virtue of notification to the Department of Health and are not applied on a case-by-case basis in response to perceived risks. In that regard, I also refer to paragraph 15 of the attorney's written case at pages 29 to 30. So the attorney's position is that there's no case-by-case analysis and there's no convention-compliant assessment that's justified in the particular circumstances. And I say that's just not right because of the application of the Human Rights Act. In other words, my position is the must in clause 4 requires to be qualified by reference to the Department of Health's obligation under section 6 of the Human Rights Act. And in that regard, I would refer to the case of RR against the Secretary of State for Work and Pensions, which is cited by Justice. That's at tab 66, page 736 of the electronic folder. and in particular, I'd refer to paragraph 29. Paragraph 29 on page 736, which says that the obligation in section 6.1 is subject to the exception in section 6.2, but this only applies to acts which are required by primary legislation. Again, under section 3.2, primary legislation which cannot be read or given effect compatibly with the Convention rights must still be given effect, as must subordinate legislation if primary legislation prevents removal of the incompatibility. If it had been intended that the section would not affect validity, continued operation or enforcement of incurably incompatible subordinate legislation where there is no primary legislation preventing removal of the incompatibility, the Human Rights Act would have said so. So, essentially, my submission leads to another reason to reject the Attorney General's argument that Clause 5.2a is not within legislative competence because it would be incompatible with Convention rights. That penal provision will only be engaged through the establishment of a safe access zone where the Department of Health is satisfied that in the circumstances of any given request for a safe access zone, it would be a proportionate interference with the Convention rights of potential protesters. That is sufficient, I say, to render Clause 5.2a within the legislative competence of the Assembly. This now leads me on to my submissions on proportionality.
Lord Advocate, can I just ask a question before we go on so that I've got this quite clear? Because I have some difficulty with the proposition as to how it would operate in practice.
Yes.
You're basically saying that where there is subordinate legislation which says that a particular institution must do something, that institution can ignore it if it considers it to be incompatible with Section 6.
So
in terms of Section 6.
Yeah. Yes.
Is that what you're saying?
Yes, because you have a Section 6 duty to act compatibly with the Convention.
So you get a specific direction from a democratically elected body that their institution must do something, and that institution itself can simply say, we are not complying with that because we think it is incompatible with the Convention, even although there has been no challenge to that made by anyone in legal proceedings.
Well, I think you can't contract out of the Human Rights Act, and I think that's what RR against Secretary of State for Work and Pensions that I've cited says.
Well, I appreciate what's said in the cases, but interesting to see how that would actually operate in practical terms within.
I think they need to, well, as far as they can, read into the provision a method by which to give effect to it, which is compliant with their duties under the Convention. So,
that's what you're saying. That's what you're saying. Yeah.
Yeah. And I think it's not just what I'm seeing, but it's what I see the text from the Supreme Court tells me. So I was now moving on to submissions on proportionality. And I would say that in any given case, the public authority who requests and the public authority which grants the requests will require to be satisfied on the particular facts that a safe access zone would be justified and compatible with the Convention. That will require there to be facts and circumstances justifying interference with rights under Article 9, 10 and 11 in the context of protecting the personal autonomy rights under Article 8. So in my submission on the proportionality exercise, it's made in that context, and that emphasises again the fact-specific nature of any proportionality assessment. And I add into that initial proportionality assessment and the check by the public authorities, the proportionality of any prosecution and conviction, which will be further addressed should a person be charged under Clause 5.2 of the offence.
So are you saying this court should express no view itself as to whether this is proportionate interference or not?
Well, I think the question that's been, the court should answer the question that's been asked, which if I return to the original question, which is whether the penal sanction with no provision of a reasonable excuse created by Clause 5.2 is outside the legislative competence of the Assembly by virtue of Section 6.2c of the 1998 Act, as it involves a disproportionate interference with Article 9, 10 and 11 rights of those who seek to express opposition to the provision of abortion treatment services in Northern Ireland. That's the question before the court. And I think on the analysis I've undertaken, the simple answer to it is yes, it is within the legislative competence. But if, no doubt, and I think...
We have to give some reasons.
Yes,
why.
that's what I was going to come on to say.
Would those reasons include, should they include, our view as to whether this balance has been struck in a proportionate way or not? We just leave that open for the individual clinics and the Department of Health and the magistrates in due course.
That's what I am suggesting has to happen, because of what the European jurisprudence tells us and what we know from all the cases, that really these issues can't be determined in the abstract and require to be fact-specific. And there's a very careful fact-specific exercise that has to be undertaken, which indeed was done by the court in Lee Brown. So I say the answer is yes, it's within competence, and I understand, though, the very significant public interest issues that are before the court and the very challenging issues that present to women who are seeking abortion services faced by the sorts of behaviour that's been described before the Northern Ireland Assembly, and indeed behaviour that's been recognised within Scotland, to try and ensure that the women's Article 8 rights are protected and that they have safe access to abortion facilities. So I see that if this court is concerned about aspects of the legislation that would merit being re-looked at and reconsidered by the Assembly on a reconsideration, or even just in light of points made by this court, then that would be a very valuable exercise. And indeed, for my part, a valuable exercise to inform the legislative process that's to be undergone in Scotland on this very same issue. But I see the answer is yes, it's within competence, and there are all number of areas in which the Human Rights Act comes into effect in order to ensure that the balance between competing rights of individuals are properly considered and protected in the establishment of this new regime. And at all different stages of the process. I think I'm being assisted here in perhaps a better response to Lady Rose's question, is that the court can express a view on proportionality on the face of the bill. Individual cases may require to be looked at a later date. I think that's just in line with what I'm saying.
That's the opposite of what you've just said.
Yes.
So which is it that you're saying?
Well, I think I'm saying, and it's not the opposite of what I was just saying. My position is that you answered the question, and it's obviously, in my respectful submission, the terms of this bill are plainly within the legislative competence of the Parliament. This is an ab ante challenge, and I've explained that there are all sorts of protections that would be in place in the creation of a safe access zone and the prosecution of individuals in that. But it would be open to this court, if they chose, to express a different view from that in respect of which I'm saying. But my point is it's within the legislative competence of the Parliament. I'm just hoping to answer your question as freely as I can. It's not the opposite of what I'm saying. It's I hope, as full an answer as possible to the question reasonably posed by my lady. I was going to come on to look at the case of Duogirio and to also look at the cases that were referred to by the Commission in their intervention that looked at the way in which, for example, the Australian courts had dealt with these issues, but it may be that we
have to do so quite rapidly.
Yes. Well, I think that the better thing to do would be to hear from the Commission on that, because they have, I think it's to answer my Lord's point about these very important cases that look particularly at the question of silent protest. And my point is that essentially it doesn't matter if it's noisy or silent or a prayer. It's the effect of the conduct is targeting a vulnerable group, and it's targeting them directly, and it's a target that doesn't involve debating a political issue. It doesn't involve debating an issue with the legislature, for example, over the legality of abortion. It's targeting a particularly vulnerable group at the most vulnerable point in the process that they're going through, which is going through the doors of the clinic. And I question whether or not, actually, in that context, the rights of those in a safe zone under Articles 9, 10 and 11 are actually engaged. Is this actually a process of protest? Is it not actually simply targeting a vulnerable group in order to persuade them to do something other than they have decided to do? So I think I can complete my submissions there. I take no issue with the proportionality exercise set out, for example, in Bank Mellet against Her Majesty's Treasury. And I want to say essentially the short point that I make in conclusion is there is no necessity to build in a reasonable excuse defence to clause 5.2a to make it convention compliant. The bill provides a framework for safe access zones and prohibited conduct within those zones in order to protect the Article 8 personal autonomy rights of women. The facts of any given situation may justify the public authority requesting a safe access zone. The Department of Health will require to consider that request and determine if it's justified, and any subsequent prosecution and conviction will require to be proportionate. In relation to the processes and procedures surrounding compatibility issues, I can provide a proper detailed response to that in writing after today, if that's helpful to the court.
Yes, I think it might be helpful to have a written note of that.
Yes.
We don't really need to know about appellate processes, at least
Yes.
speaking for myself. It's really, our interest is in knowing how things would be handled at first instance.
Yes, thank you, Lord.
Could I just ask one question before you sit down? And it's probably because I didn't catch precisely what you were saying. You identified 3 categories from Kukurian.
Yes, I did.
The first, I understand, were reasonable excuse. The second is where there's the ingredients of the offence itself are regarded as proportionate. What was your third?
The third reflected what was said at paragraph 70 of Kukurian.
Right, because the Lord Chief only himself identifies 2 categories. So this is your interpretation to set up a third, and it's at paragraph 70?
Yes.
Thank you very much.
And I think that the court actually in Kukurian did go on to do that exercise in any event. They did go on to do that proportionate exercise in any event, I think, before they sent the case back for redetermination at first instance, as I remember.
But it's where on the facts there would need to be a proportionality exercise. Yes, thank you very much.
Lord Advocate, I've just got a Scottish-specific question in relation to some of your submissions. As I understand it, you were suggesting that there could be a compatibility issue relative to the acts of the Lord Advocate.
In bringing prosecution.
Well, I thought we abolished that.
Ah, yes, that's right. Yes, I'm sorry. Yes, yes, that's right. My Lord's correct. Yes, that's the old.
That's the old system. Yes. Yes. Right. Thank you. That was all.
Yes, thank you very much.
Thank you very much, Lord Advocate. Mr. Blundell.
My Lord, my ladies, the Commission is grateful to the Court for the opportunity to present submissions by way of intervention in the present proceedings. If I may, what I'd like to do today is to cover 3 issues in my submissions. And let me just outline what they are now. First of all, issue 1 is to deal with the historical position and the legal relevance of the historical position of women and girls seeking an abortion in Northern Ireland, and in particular its relevance to the Article 8 exercise the Court has to undertake. Secondly, issue 2, I want to look at some of the evidence as to the adverse impact of anti-abortion protests on women and girls seeking to access abortion services, particularly with regard to the sorts of actions falling within Clause 5.2a, which is obviously at the heart of Mr McGlennan's case in this challenge. And then issue 3, I wanted to look at the nature and scope of the potential interference with Article 10 ECHR rights of freedom of expression, which actually exists by virtue of Clause 5 of the bill. So can I begin?
Could I, before you begin,
of course.
Could I request a 4th item, and if need be, give you additional time to deal with it, possibly after the adjournment? That's really for assistance in understanding how in Northern Ireland the criminal procedure would handle any proportionality issue. The sort of matters I was raising a minute ago with the Lord Advocate. If the Court takes the view that there may be cases where the proportionality of proceedings and obviously, yes, proceedings was challenged, how would it actually be dealt with at first instance in the Northern Ireland courts?
Yes. Well, of course. May I come back to that perhaps after the short adjournment? That would be
absolutely.
If I could have that opportunity. I'm grateful. My Lord, then, and reserving that point a little later, can I begin with issue 1, the historical position of women and girls seeking an abortion in Northern Ireland? On that first issue, the starting point is, of course, now that women accessing abortion services in Northern Ireland are making what is a lawful and private healthcare decision, and one of the most personal and sensitive kind. But they do so against the historical background of the previous criminalisation of abortion in that jurisdiction until very recently. The legal relevance of the historical position to the Article 10 analysis is the Strasbourg Court's statement in the Perinchek case, which you saw yesterday. That was the case about the Armenian genocide prosecution. The statement that in reviewing whether there exists a pressing social need for interference with rights under the Convention, the Court has always been sensitive to the historical context of the high contracting party concerned. And for the Court's reference, that's paragraph 242 of Perinchek in Supplemental Authorities, Volume 8, Tab 77, SEF 1137. I don't ask the Court to turn it up in the interest of time, but that's where that statement comes from. And the Court went on to state that the respective states' historical experience had been a weighty factor in the assessment of the existence of a pressing social need in several cases, and it gave a number of examples. The uniquely difficult experience of women seeking access to abortion services in Northern Ireland, particularly compared to the rest of the United Kingdom, was specifically considered by the Assembly in deciding how to craft the bill. And to make good that proposition, may I take the Court to just 2 very short passages in the Assembly debates. They are in the appendix, and the first one is at page EF 120. I just ask the court to turn that up. So legal context set by Perrincheck. In the debates then at page 120, the court will see towards the bottom of the page an entry for 1 p.m. This is Mr. O'Toole speaking. And he says this: "It's also worth saying that the right of women to seek reproductive health care has been denied in this society for decades. It ill behoves those who now complain about the right to freedom of assembly, free speech and protest to talk about rights, given the systematic denial of women's rights to seek the basic reproductive health care that existed in other parts of, yes, the United Kingdom. Some of those same people are very good at reminding us about the rights attached to citizenship of the UK, but they did not want rights for women in this place for a long time. Women now have those rights, and they should be able to access them without harassment and threat." That's then the start of a debate that continues. The second passage, if I can just take the court to, is at page 128. EF 128, and this is approximately in the middle of the page, below the timing 3:45 p.m. Can I just ask the court to read that single paragraph that begins "another issue that was raised"?
Do we have the CEDAW report?
We do, my lord, and that was the next passage I was going to take the court to. So, if that's a convenient moment, that's behind tab 110 in volume 10 of the Supplemental Authorities. It begins at page SEF 2074. Can I ask the court to turn that up? So, the background, as I say, to this submission is legal relevance of historic position set by Perrincheck. Factual position is the Assembly did in fact consider this. And given the cross-reference to CEDAW, let me show you what's said there. Sorry, I said 110. I'm so sorry, that should be 105. My apologies. Tab 105, SEF 1971.
1971.
1971, my lord, that's right.
Yeah.
So this is the report of the UN CEDAW Committee. It's the report on its inquiry concerning the position in the United Kingdom. Just for context...
sorry, page...
so it's SEF 1971.
Thank you.
My apologies. So just for chronological context, this is a report which was produced shortly before the previous proceedings in this court brought by the Commission on the criminalisation provisions in Northern Ireland, and it's referred to in that judgment. It's dated the 23rd of February 2018. Again, to put this into context in terms of what was going on at the time it was examining, if the court looks at page SEF 1974, you'll see at the top of the page, paragraph 13, institutional and geographical limitations at small letter A. In 2015-2016, only 46 abortions were performed in Northern Ireland's public hospitals, yet in stark contrast, 724 women travelled for an abortion in England. Now, at that stage, abortion was, of course, generally criminalised. The only circumstance in which an abortion could be lawfully performed was if the common law test in the case of born was satisfied, which in effect required the continuation of pregnancy to lead to the woman becoming a physical or mental wreck, and there's discussion of that in the judgment of Lord Mance in the first set of Commission proceedings. So that explains why there was such a small number of abortions lawfully being carried out in Northern Ireland at the time. Nonetheless, there were still protests at that point, and one sees the fact-finding, so the facts as found by the committee, at paragraphs 19 and 20, so that's SEF 1975. Could I just ask the court to read those two paragraphs?
Well, that's very graphic.
My Lord, it is. And it's consistent, as the court will appreciate, with the sorts of evidence that you'll see elsewhere in the papers. I will be making reference to one or two passages. I won't labour the point, because the court has the issue and it's there in other context. But these are findings of facts by the relevant UN treaty body for the purposes of its report. What they led to was obviously the conclusion at 20 that despite the limited legal provision, effectively it was impossible to access, and part of the reason was the impunity of anti-abortion protesters for assaults perpetrated against women. So that, again, if one stands back for a moment, that's the context to what the Assembly is dealing with. That sets the context, the historical context, relevant per parent check for the Assembly's task. It then leads to a recommendation by the committee, and that's on page SEF 1978. You'll see, in fact, at 1977 that there are two sets of recommendations. There's a first raft of recommendations on the legal and institutional framework, paragraph 85 and down, and then at B, sexual reproductive health rights and services over the page, and at letter G, protect women from harassment by anti-abortion protesters by investigating complaints, prosecuting and punishing perpetrators. So again, certainly on the international plane, that is the legal context for the task which the Assembly, in part at least for the task which the Assembly was faced with when it came to consider how to craft a bill in these terms. My ladies, my lords, we say that's significant. We say it's significant that even in the very limited circumstances in which abortion was available at that time in Northern Ireland, the international treaty body nonetheless found itself compelled to come to those conclusions and make that recommendation. And that has a direct legal relevance to the assessment of the Article 10 question because of the terms of parent check and what that says about member state historical context. My lords, my ladies, that's what I wanted to say on my first issue about the historical position and a consideration of it by the Assembly. Now I move to my second issue then, which is evidence of impact of protests on women and girls seeking an abortion. And the available evidence, my Lord Kitchen has already referred to the graphic nature of it in the CEDAW report, but the available evidence demonstrates that anti-abortion protests, and particularly we say those falling within the scope of Clause 5.2a, which is where Mr McGleenan lays down his fire, have a real, serious and detrimental impact on the ability of women to access abortion services in Northern Ireland, as well as an impact on the providers of those services. And I appreciate that's a point that's come out a little in argument over the course of the last 2 days. I'll come back to that in just a moment, if I may. I've already referred to the findings in the CEDAW report. We also identify some other evidence, and there are two reports in particular I wanted to show the court. The first is the March 2018 submission of the Royal College of Obstetricians and Gynecologists. This was a submission to the Home Office Abortion Clinic Protest Review, and the court will find it, again in volume 10 of the supplemental authorities behind tab 110. That was the reference I erroneously gave you earlier on for the CEDAW committee. So it's the last tab, and that begins at SEF 2074. This dates, although it doesn't bear a date, the date is March 2018. There was effectively a consultation carried out by the Home Office in England and Wales. I'm so sorry, SEF 2074.
Thank you.
Into possible legislation in this field. The ultimate decision was taken in this jurisdiction not to proceed with that legislation.
March 2018, did you say?
March 2018, my lord.
Yeah.
So it's the Royal College's submission. And it deals in detail with the sorts of protests that occur. Perhaps I can just run through a little of it. On that first page, you'll see again similar sorts of activity. Below, well, towards the bottom of the page, below the bold question, have you knowledge of protest, etc. So yes, we have serious concerns regarding ongoing intimidation and harassment. The next paragraph down, we're aware of anti-abortion picketers harassing women in a variety of different ways, including filming individuals approaching clinics which provide abortion services, giving them unsolicited advice which is contrary to that provided by doctors. That, of course, would be of particular concern to the Royal College, the provision of incorrect medical advice, and providing grossly erroneous information about clinical risks, such as linking abortion with breast cancer. And then there's a reference to the impact, unsurprisingly, that has on the women, but also a direct impact, the court will see there, on staff well-being, causing them to feel unable properly to support and protect patients. Now, perhaps if I can headline a submission I'll make in due course, we say it can't be ruled out, as Mr McGleenan seeks to do, that in fact the impact on the other categories of protected person may well engage Article 8 rights. With staff, of course, it's well established under the Article 8 private life limb that the ability to interact with the external world through the ability to exercise a profession or engage in a job may engage Article 8 protection. So there is a possibility certainly for the staff to have Article 8 rights engaged, and indeed potentially also for those who accompany the women. But even if that is not correct, the nub of the point is really this. It's essential to protect those individuals also in order to protect the women who are accessing the services, because it doesn't take an awful lot to conceive of circumstances in which a woman already in an extremely vulnerable situation, you've seen the evidence the Commission produced in the first set of proceedings about rape, incest, serious fetal abnormality, all the rest of that, not being able to be accompanied by somebody who is supporting them in that very difficult position as they walk through the door of the clinic, and furthermore, not being able to get the professional support that the clinicians and the professionals giving this evidence feel they are required to give would make the woman's position intolerable and indeed impossible. So I headline that point now, but that's the issue I'd come on to later on. Just going over the page again, really it's more of the same. I don't want to go through all of this. If I could ask the court to read it in due course in its own time. I will just highlight at the top of page SEF 2075, you'll see that the Royal College is giving evidence not only about England, Wales and Scotland, but also Northern Ireland. So it covers the entirety of the jurisdiction. Also has close contact with academics and researchers. Again, then, halfway down the page, under the question, what is the nature of the activity? You'll see some of our members highlight it includes regular protesting, praying, holding Bibles, singing around religious pictures, giving out very medically inaccurate and emotionally charged leaflets, and engaging in activities that draws attention to the clinic building. It's, to some degree, both the silent prayer vigil and also what's called in some of the Commonwealth case law, sidewalk counselling. It comes under different forms. But it's absolutely, we say, the sort of activity that would fall within 5.2a and not necessarily 5.2b or c. And again, then, there's more detail as to the next question about the impact of that, leaving not only patients but staff angry, uncomfortable, etc., and so on and so forth.
And there's an interesting account on the next page of the effectiveness of buffer zones introduced in Australia.
Absolutely. Well, that is part of the reason we put this in. One of the unusual facets, of course, of this being a pre-consent reference is that there's been no findings of fact on relevant material before a first instance court. And of course, that's just a feature of the way the devolution legislation works. But that's why we thought it was important to put this material before the court, so you can at least see not only the experience in this jurisdiction and throughout the United Kingdom, but also the experience of the operation of legislation in other areas of the Commonwealth. And you'll have seen also that we have an annex which summarises some of the Commonwealth legislation in this field.
At the top of the next page, ending in 7.7.
Although that's the next passage I was going to ask the court to read. Could I ask you to read those three
paragraphs? The first paragraph supports what's said in the... I mean, that's evidence from doctors supporting what was found by the High Court of Australia.
Absolutely. It's exactly the same finding.
It may seem a small point, but do we know anything about the extent of these zones that were being imposed in these other jurisdictions? Were they of the sort of order that we're concerned
Yeah,
with?
so I think I can say this, they vary, and that is something we've tried to summarise. We tried to do this as uncontroversially as we could, given the 20-page limit. We put it in an annex to our written case. But that annex, perhaps I can give the court the reference, you'll see the summary there.
I don't want to distract me, but if you just give me the reference.
Yes, of course. The annex begins at supplemental EF page 80.
Yeah.
And you'll see, just if the court turns there for a moment, for example, Australia, Queensland, safe access zone, paragraph 2, 150 metres. Potential prison sentence of a year. New South Wales, 150 metres. Australian Capital Territory, by contrast, paragraph 4, 50 metres and no bigger than necessary. And so on. I won't go through all of them, but we've tried to set out those key features of the legislation so that a comparison can be made. And if I can put it this way, the punchline of the submission that goes to that legislation is that certainly the choice, the legislative choice, after an informed debate in the Assembly here, is one that is entirely in keeping with the legislative choices made throughout the Commonwealth world. Indeed, it's more modest in some respects because it starts with 100 metres. It's more extensive in other respects because it's able to be extended to 250 metres. But just to put that in context, by reference to a landmark that this court perhaps will be familiar with, the frontage of the Palace of Westminster is approximately 300 metres long. So even if you have a protest zone at its maximum extent of 250 metres at one end of the palace precincts, you could lawfully have, under this legislation from Northern Ireland, a protest within sight and sound, to borrow the language from the Russian cases, before the other end of the palace precincts. And of course, if it was only a 100-metre zone, then it would be approximately a third of the way along. But just to put that in practical context.
These are unlikely to be open spaces of that.
And of course, yes, it may not be within sight and sound because of the road layout, but just to give a feel for what that actually looks like on the ground.
100 metres is measured from where? From the entrance? Or
from the entrance.
Oh, from the entrance.
The entrance. So, my ladies and my lords, I was about to take you to those.
Well, when you say the entrance, I think it was the premises, isn't it?
I think it was the premises.
Premises, I'm sorry.
Which may not be the entrance.
Yes, yes, I'm sorry. I think that's right. But those were the three passages I was going to take the court to in the Royal College's report. And we say that is a useful analysis, and particularly in terms of a comparison of application and indeed impact as well. And to pick up then the point that's just been made about the cases, the kind of activity that is being examined in the context of 528, Mr. McGlean, I think, has taken as the sort of high point of his submission, the silent prayer or the prayer vigil. And that's something that you see referred to there in the evidence. We rely on what's said about the actual impact of that. And indeed, we say that it's self-evident that could have a very, very serious impact indeed. It's considered in the cases as well. Domestically, there's the Dulgariu case in the Court of Appeal. You've already seen that. The reference is paragraphs 59 and 60, and that's in Volume 1, Tab 6, EF 550, cited in our written case at paragraph 39. I don't seek to show the court that. You've already seen that. But can I take you, though, to the Australian case of Club? Now, that is in tab 9.
Can I just take you back to the 100 metres there? I was just looking again at 4.
No, it is entrance.
42B.
Sorry, in the legislation.
Yeah.
Sorry.
I think you were correct, actually. It does say.
I conceded the point too quickly, perhaps. Sorry. It's the danger of responding to a challenge.
Each entrance to or exit from.
Yes.
The premises, yeah.
So I'll go back to my first answer. I'm so sorry. I should have checked that before I responded to my Lord's question.
Yeah, so it looks as though the extent would depend on really the type of premises.
Yes.
I mean, if it's, for example, a hospital surrounded by land, then it seems to be 150 metres from the perimeter. But if it were simply
Yes.
a building, say, that you walk in off a public
On
street,
the street.
then then all would be protected would be the public area lying within 100 metres of each entrance or exit.
Yes, and in fact, there may be some relevance in that because, of course, on a hospital site, it may well be you have the provision of other medical services, and so having the zone start from the entrance, perhaps to the hospital grounds, serves a utility, and not having the other patients accessing hospital services also disturbed by what's going on. And that, again, is a factor that comes across in some of the materials. It's dealt with in the Assembly debates at EF 98. They deal with the fact that you often have, for example, women accessing services to do with medical problems over pregnancy in the same overall location as a provision providing abortion services. And of course, for them, seeing perhaps very graphic photos of late-stage abortions may be a deeply distressing experience, but for a slightly different reason. So the fact that it starts from the exit to the premises in a hospital case, we say has a good foundation.
Yeah, there's also an interpretative provision in 9(2)(b),
Yes.
but I don't think we need to delay ourselves on this.
Yes. Yes, that's right. Parts of buildings. Well, so that's that. I was taking you to the Clubb case, Clubb and Edwards. It's actually two joint appeals, Clubb and Preston. They examined the lawfulness of legislation in Tasmania and Victoria dealing with safe access zones. The consideration of this issue about silent prayer, one finds was clearly set out in the joint judgment of Chief Justice Kiefel and Justices Bell and Keane. That's SEF page 1369. I'm not sure I said, but this is, sorry, volume 9, tab 80. 1369, and it's paragraph 89, where you'll see this. Silent but reproachful observance of persons accessing a clinic for the purpose of terminating a pregnancy may be as effective as a means of deterring them from doing so as more boisterous demonstrations. Further, there is a pragmatic consideration that the line between peaceful protest and virulent or even violent expression against abortion is easily and quickly crossed. So, my Lords, we say that's an entirely correct assessment of the position. One can't simply say because it's a silent prayer or a prayer vigil, it's not going to have an impact. The impact...
Here they're talking about a case from Victoria, which
Yes.
has a charter, doesn't it, of rights?
Yes, the legal context for the consideration of the issues that arose in terms of freedom of expression and rights of other persons is, of course, slightly different in the Australian context and slightly different in the States.
Yeah.
When we entirely accept that, you can't simply transpose, for example, the legal analysis in these cases. So, for example, there is a very detailed, in some ways quite esoteric debate between some of the justices about the proper approach to structured proportionality.
Yep.
And there's very detailed consideration of that. That is obviously not relevant for the kind of considerations that arise in this case. What we say is relevant is some of the consideration of the specific facts that arise, or the factors that have to be considered. For example, the impact of silent prayer, and so on and so forth. There's also a very useful debate, and as we're in the case, perhaps I can take the court to it, a useful analysis of the fact that what women are doing here is implementing a private healthcare decision, not making a political statement. And that's a little bit further on in the same, in the judgment rather of Justice Nettle. Perhaps as we're in the case, can I take the court to that next? That begins at paragraph 249 on page 1424. And it's a very important discussion because we say it sets the context for the same analysis in terms of Article 10 here. So it's at SEF 1424. Could I ask the court to read paragraph 249, 252 and 253? My lords, my ladies, perhaps to highlight one sentence in particular, the one at the end of paragraph 249, by contrast, a communication between a woman and her doctor as to the possible physiological and psychological sequelae of the woman undergoing an abortion is an apolitical personal communication. That, we say, provides the proper context for the sorts of influence which the protesters are having in these cases.
Yeah. There's also quite a good passage from an earlier judgment of Mr. Justice Nettle, cited at paragraph 97. That was back on the page you had us at earlier.
1371.
Yeah.
Yes, yes. And my lord, that chime, that's in essence making the point that there's no right to a captive audience. And so what Mr. Justice Nettle says at 1371 in that earlier judgment in Brown is that the implied freedom of political communication is a freedom to communicate to those willing to listen, not a right to force an unwanted message on those who don't want to hear it. It's that first bit. And still less so by preventing or restricting a listener's lawful business activities. Now, so much for lawful business activities, a fortiori, but what's being protected here are the Article 8 rights, long denied, finally provided, albeit not, of course, in practice. Those services are still not commissioned in Northern Ireland. There's been separate litigation on that. But a fortiori, we say that a point applies here. That also finds reflection in the Canadian case law. Given the time, I won't go to that, but can I give the court the references? So the relevant cases in Canada, which we've provided, which deal with no right to a captive audience, are Crown and Lewis, which is Supplemental Authorities, Volume 9, Tab 83, SEF 1668, at paragraph 142, SEF 1747, and also the Court of Appeal of British Columbia in Spratt, same volume, volume 9, tab 84, SEF 1751, paragraphs 82 to 86. You will see there, of course, also citation of the Hill and Colorado litigation in the Supreme Court of the United States. So it takes a slightly different approach to free speech under the First Amendment.
The case starts at 1751, does it?
1751, that's right. And the relevant passage starts at 1781. The other reference I had in my notes to give you was, in fact, this passage at paragraphs 97 to 100 from Club. So my Lord's beaten me to it.
Yeah, where again, the judge speaks about captivity. It's liberty.
Absolutely. And my Lord, it's relevant we say that Mr. McGleanan hasn't shown the court any case law in the convention space which would countermand that particular point of analysis.
Well, how can that the only right that you have is the right to communicate ideas to those who are willing to listen? That doesn't. Seem to be what the Strasbourg case law on sight and sound seems to
No.
involve.
Well, the sight and sound principle in the Strasbourg case, in those Russian cases, we say is quite context specific. The legislation in Russia generally imposed a ban on protests throughout the Russian territory. It was incredibly stringent legislation. But even applying that principle, there wasn't in the Strasbourg case law any consideration as regards sight and sound of countervailing factors, so the engagement of other convention rights on the other side of the balance. Secondly, it was only a factor to be taken into account, an important one, I don't seek to suggest otherwise, but it's one factor, it's not an absolute test, the sight and sound principle. And we say here, given that you have the engagement of the sorts of rights of women and girls that are at issue here as the other side of the balance, even taking that into account, given the scope of the legislative intervention with the 100-metre zone or the 250-metre zone, there's nothing which truly offends that provision. It's no absolute bar to legislation of this sort.
Well, also the people in Northern Ireland who have very strong views in opposition to abortion can have the prayer vigils or the demonstrations, but outside of the area.
Absolutely, absolutely.
I mean, so that's part and parcel of the argument you make, I think.
It is, my lady, that's absolutely right. And the final point I was going to come to, and I see that...
That's what we need. It's put in put in a slightly more subtle way in the second of the BC cases, where they cite a judgment of the Canadian Supreme Court and also one of the United States Supreme Court.
Yes.
The gist being, as they put it, that freedom of expression assumes an ability in the listener not to listen, but to turn away if that is her wish. And
exactly.
The sort of situation we're talking about, there isn't that ability.
No.
So it's in that sense that they are captive listeners.
They are captive, and if they wish to go ahead and access the facilities of the clinic, they have to run the gauntlet.
Yeah.
They have to run the gauntlet of the placards and the prayers. And so they are captive in that sense if they wish to avail themselves of their lawful rights. So it is a subtlety that's not considered there, but that provides, in my submission, a fortiori very powerful basis for finding that this legislation strikes an entirely appropriate balance. Then, of course, there's the sorts of points that my lady, the Lady Chief Justice, was just mentioning. So, for example, the fact that you can still make all those protests in a different area, in fact, quite close, literally just down the road. And there's nothing unlawful about that. This isn't the sort of legislation that says you can't say this at all anywhere. Equally, it is viewpoint-neutral legislation, to borrow the language of some of the Commonwealth case law. My Lord, I appreciate I've slightly trespassed on my 30 minutes.
Yes. Well, I think we'll adjourn just
Yes.
now.
Can I come back with the response to my Lord's fourth point after that?
Well, in relation to my fourth point, it's occurred to me that what might actually be better, rather than trying to get submissions in a rush on this,
Yes.
would be if you and counsel for the Attorney General were able to confer on this and perhaps produce an agreed note of the procedures that would be followed.
Yes.
And perhaps if you both and the Lord Advocate could provide your respective notes within, say, 14 days.
My Lord, absolutely will do that.
And that's what we'll do then. Well, we'll adjourn just now, and unless you have any further thoughts that could be conveyed to us very briefly, then we'll then go on to Mr. Grant.
Well, if I can just review it over lunch then. Very grateful indeed. Thank you.
Yes, Mr. Blundell.
My Lord, you kind of indicated I could just review my notes over lunchtime, which I've done. Can I just really flag 3 points? I'll do it as quickly as I possibly can. I won't take any time over it. The first is that when I was dealing with my second issue, I told the court there were 2 reports I was going to go to. The first was the Royal College report. Can I just give the court the reference to the second? It's the Committee for Health report on the bill, and it's in Appendix, which is at tab 3, page 128 is where it starts, EF 207, and the relevant extracts are in fact set out in full at paragraph 10A of our written case, which is supplemental EF, page 62. So I don't make any submissions on that, you have the material there. The second point of the 3 was just one issue that I was about to come to just before the luncheon adjournment, was to say a very brief word about the criminality provision in the bill and the nature of the criminal penalty. And the submission is this: we accept, obviously, as we have to, that the bill does impose a criminal sanction for breach, but it is a minor one. And as to the significance of the severity of a criminal penalty, we pray in aid this court's decision in the Poor case. That's Authorities Bundle, tab 3, volume 3, tab 30, EF 1327. That's the case about terrorism offences concerning the carrying of articles which raise a reasonable suspicion that the accused was a member of a prescribed organisation, so terrorist-related offending. In that case, the offence was triable summarily and carried a penalty of 6 months imprisonment. You can see that from paragraph 17 of the judgment.
Can I check I've got the right page number? I
Yes.
think you said 1327?
I did, my lord. I hope that's correct. Let me
In which bundle?
bundle.
The main electronic bundle or the supplementary?
The main one, and it's behind, that's right. It's the main one, volume 3, tab 30. 1237.
Right.
I'm so sorry, my lord. 1237.
Yeah.
My mistake.
Which paragraph was it?
So paragraph 17 sets out the penalty at 6 months, and then paragraph 68 at 1257, the court finds that one of the primary reasons why the legislation, not the only one, but one of them, why the legislation struck a fair balance was because the criminal sanctions were comparatively minor. Now, what we say is compare that to the position with Clause 5, where there's no question at all of imprisonment. My Lord Reid asked yesterday whether the level 2 fine was £500, and it is, under the legislation currently applicable. I've already made the point that a number of other jurisdictions back this sort of legislation with a criminal sanction involving imprisonment. There's also the point, of course, that you will have seen made in the Assembly debates and elsewhere, well, what about other criminal sanctions that could be used instead? What we say about that is the use of a criminal sanction to prevent somebody in the first place from doing it, so for example through harassment or something like that, it is not very much use where it doesn't assist the woman in actually gaining access to the facilities in the first place. That's why you need the safe space. So prosecution for harassment may be difficult because you need a course of conduct, but it's of no comfort to a woman who can't access the facilities and is then abused for trying to do so. So we say that's a relevant consideration when you're looking at that part of the balance. And of course, also, this needs to be seen in the context of Clause 6, which provides a power for a constable to remove somebody from the area without necessarily moving to prosecution thereafter. So there is a gradated scheme of enforcement here. My lords, my ladies, that was my second point. The third and final point I wanted just to flag was simply to explain why it is you had 2 cases from us on your desks overnight. I apologise because one of those, in fact, was already in the bundles. That was our oversight. I apologise for that. There are cases of DS, which you were taken to by the Lord Advocate this morning, Lord Hope's speech at paragraph 24. The second case is the case of ANS. We rely there on paragraph 17 of my Lord Reid's judgment, It's about the proper approach to Section 3 reading down in a devolution challenge such as this, and it cites the approach of Lord Hope in DS. You have those authorities there. That's what they're there for. My ladies, my lords, I'm extremely grateful for the extra time after lunch. Unless there are any further questions, those are my submissions on behalf of the Commission.
No, thank you very much indeed, Mr.
Grateful, my lord.
Ms. Nagrali.
My ladies, my lords, Justice is very grateful for the opportunity to intervene in this case. And we do so on what is, in essence, a point of statutory construction. That is that an express lawful or reasonable excuse clause is not a prerequisite for a criminal court to assess whether a conviction would constitute a proportionate restriction of a defendant's Article 9, 10 and 11 rights on the facts of a given case. It's a narrow point, but it is a very important one in circumstances where the Attorney General's case is that an express reasonable excuse clause allowing for a proportionality analysis at trial would, in Dr. McGlean's submission, be curative of the matters that have been raised by the Attorney General in relation to Clause 52A. Now, our submission is that there is no need for that cure. Pursuant to Section 6 of the Human Rights Act, a court, including a magistrates' court in Northern Ireland, may not act in a manner incompatible with Convention rights. It is unlawful for them to do so under Section 6.1 of the HRA. And that means that where Articles 9, 10 and 11 are engaged, absent clear statutory language to the contrary, a court cannot act to convict a defendant unless they're sure that a conviction would constitute a proportionate restriction of those rights. Now, that's not leaving things to the vagaries of litigation or relying on summary prosecutions to develop the law. It's a straightforward issue of legality, and proportionality is in that way baked into the clause, just like it can be baked in with an express lawful excuse clause. So that's my overarching submission. And in the short time that I have available to me, I'm going to focus my oral submissions on that issue and on two subsidiary issues. And they are that, first, as a matter of Strasbourg law, the general measures doctrine of animal defenders has no proper application in a criminal context in cases balancing qualified rights. The second is that lawful excuse clauses and reasonable excuse clauses are not synonymous with Article 9, 10 and 11 proportionality. It is perfectly possible for a criminal provision which does not include such a clause to be given effect in a manner compatible with Convention rights in an individual case, as indeed Dr. McGlean himself acknowledged in the case of Lee Brown when he was acting. Now, I'm necessarily going to take those points very quickly, so I don't propose to turn up documents unless strictly necessary. But before I turn to those three substantive submissions, a few just preliminary points. The first is that underlying Justice's intervention is the fact that numerous offences engaging Articles 9, 10 and 11 do not include express lawful excuse or reasonable excuse clauses. And just a sample of those are set out at paragraphs 46 to 49 and paragraph 55 of our written case, which begins at page 40 of the supplementary bundle behind tab 4. And many of those offences were enacted prior to the entry into force of the Human Rights Act, or indeed prior to the drafting of the Convention. And for this court to accept the Attorney General's argument, or to determine in general terms that the absence of an express lawful excuse obviates the need for a proportionality analysis at trial, could impact very significantly on the protection of Article 9, 10 and 11 rights across Northern Ireland and indeed across Britain. The second preliminary point is that we do respectfully submit that Couturian was wrongly decided. As Dr. McGlean has highlighted, there are conflicting...
I'm sorry, I was distracted for a moment. Which case are you saying?
Couturian.
Couturian.
As Dr. McGlean highlighted, there are conflicting authorities on this, and I respectfully submit that the court should adopt the Scott O'Connelly and indeed Lee Brown line of authority rather than DPP and Couturian, which didn't consider those authorities. And in my respectful submission, neither both DPP and Couturian were wrongly decided precisely because they didn't consider the relevant Strasbourg authorities. And it's not correct to say that Couturian is in effect settled law. It's being reconsidered by the court in the Attorney General's reference in relation to the Colston appeal. Matters in relation to it is before the court again. Now, the third preliminary point that I want to raise, and I raise briefly, but it is important to do so given the exchanges this morning. Proportionality is, in my respectful submission, a matter of fact for the tribunal of fact. In a jury case, it is a matter for the jury. That was determined by this court in Ziegler, and the relevant paragraphs for that are paragraphs 59 and 60.
But not definitively. This is a larger court. You could overrule it.
Well, my lord, indeed, but there is simply insufficient time in the 30 minutes that I have to do justice to such an important proposition in a case that doesn't even raise questions about a jury trial. There is extensive authority that makes clear that it is a long-established principle in criminal law that defences involving value judgments are for the jury and cannot properly be withdrawn from the jury other than where they have no evidential bases. And that's Lord Justice Auld in Nicholson, Lord Justice Hughes in R&A, where he says the concept of reasonable excuse is par excellence a concept for decision by the jury on the individual facts of the case. There's Lord Widgery in Bellow, there's the Court of Appeal in Hammond, there's Lord Chief Justice Hughes, the then Lord Chief Justice in R&A. And there's also the case of Brown, where again it was decided specifically in the context of the right to freedom of speech. There's the householder defences that have a proportionality element built into them. Now, I would respectfully submit that if the court does intend to determine this issue, that it does allow supplementary written interventions on the matter, because it is a matter of such significant importance. It would be important to have all of the relevant authorities before the court before making such a decision that would have such significance in future cases.
Because it would be possible to argue, would it not, that while the generality of cases looking at reasonable excuse, that may be correct, what you've just said, when within that one is looking at proportionality, one might say the proportionality decision is a matter of law, albeit it's got to be applied to the particular facts.
Well, my lord, this was discussed and was debated in Ziegler, and in my respectful submission, no, the answer is no, it's not a question of law, it is a question of facts. And the authorities do establish that in my respectful submission.
So you've sort of rattled through all those cases. They are mentioned in your...
My lady, they're not, because this issue wasn't raised other than in oral argument. It's not an issue that arises on the face of this case. Which...
I see. So this issue being whether it's a question of law or fact rather than the role of the magistrate in...
Indeed, whether it's a question of law or fact, and whether it would then be for the tribunal of fact or for the tribunal of law. Obviously, the two combine in the magistrates' court, which is why I think it wasn't an issue in these proceedings. There are no distinct roles in that respect.
A related issue is whether statutory provisos dealing with reasonable excuse or lawful excuse are meant to address convention rights at all. You make the point that they can hardly, whether or not there is such a clause present, can't be decisive. And I wonder whether it's even relevant. I mean, most of the statutes we deal with that have lawful excuse provisos or the like predate the Human Rights Act, and they would have been enacted with different considerations in mind.
My lord, precisely.
It may be a way through this is to treat proportionality as a separate issue. The alleged breach of a convention right, it's particularly easy is to treat it as a distinct issue.
Well, my lord, yes, and the thrust of my submissions will be that it's not statutory provisions, it's not the elements of a crime that require a proportionality assessment, it is the engagement of the rights. Strasbourg has no consideration to the elements of a domestic crime in considering whether or not a proportionality analysis arises. It's simply, are the rights engaged? And if so, is the restriction on those rights proportionate? And in my respectful submission, that should be exactly the same position adopted by the domestic courts, as indeed it was adopted in Lee Brown. And if I can get to the mechanics of that, in response to the question by my Lloyd Jones, it's that exactly that, the requirement for a proportionality analysis at trial flows from Section 6 of the Human Rights Act, not from the elements of the offence. And that is because, as I said in my introduction, as a matter of domestic law, under Section 6.1, it is not open to a criminal court, including a magistrate's court, to act incompatibly with convention rights, other than in two circumstances. The first is Section 6.2a, where the court cannot act differently under the terms of primary legislation, and the second, which is Section 6.2b, where certain legal provisions cannot be read or given effect in a way which is compatible with convention rights. Now, neither of those categories apply in relation to this case, which concerns subordinate legislation. But even if they did, the cases of Lee, Brown, Scotto and Connolly show exactly how provisions not including a lawful excuse clause can be read and given effect in a way which is compatible with convention rights, and therefore must be so read in accordance with Section 2. So even where the exceptions apply. Now, certainly Parliament could legislate to rule out a proportionality analysis at trial in relation to a given crime to prevent the court itself doing a proportionality analysis. That's because Parliament is sovereign, it can do what it chooses. But the principle of legality explained by Lord Hoffman in Sims applies. And those principles are summarised at paragraph 55 of Bank Mellat. No need to turn it up, but it is at page 322 of the main authorities bundle. And the principle makes clear that fundamental rights cannot be taken away by generally or ambiguously expressed provisions of a statute. They can only be overridden through express words or necessary implication. So the mere absence of words, reasonable excuse, particularly, as my Lord says, in legal provisions drafted long before the Human Rights Act, is not sufficient to abrogate fundamental Article 9, 10 and 11 rights, including the need for a fact-specific assessment at trial.
Do you apply that to all offences? So if I was to give you, the most heinous physical rape or assault occasioning actual bodily harm, do you apply the same argument whatever the type of offence?
My Lord, Articles 9, 10 and 11 have to be engaged, and there are, as my Lord will know, categories of acts to which Articles 9, 10 and 11 don't apply. So violence, incitement to violence, undermining the foundations of a democratic society. They're the three exclusionary categories, particularly in relation to Article 11. So insofar as it was determined that an act was violent, so for example, if that were a matter for the jury to consider, the jury considers that it is violent, they wouldn't need to then go on and consider the proportionality analysis.
What about criminal damage?
Well, in relation to criminal damage, there is a lawful excuse clause. And the lawful excuse clause means that Articles 10 and 11 are engaged. Not all acts of criminal damage. Criminal damage can involve walking on grass, it can involve a scratch to a barrier, it can involve many different things that are extremely trivial in nature and are capable of occurring routinely in the course of protests. There's no carve-out in Strasbourg jurisprudence for criminal damage from Articles 10 and 11. So that's the position in relation to Parliament. Parliament could legislate to preclude a proportionality analysis at trial, and that's contrary to the reasoning of Katurian at paragraph 71. And that is worth turning up briefly. That's at... So the case starts at page 442, and paragraph 71 is at page 458. And the judgment says, we do not accept that Section 6 imposes a freestanding obligation on a court to be satisfied that a conviction would be a proportionate interference with convention rights if that is not an ingredient of a statutory offence. this suggestion would make it impossible for the legislature to enact a general measure which satisfactorily addresses proportionality itself to make case-by-case assessment unnecessary. It is well established that such measures are permissible, see Animal Defenders. Well, with respect, that's not correct. Parliament could act to take away fundamental rights. It just needs to say so clearly. But as a general rule, that intention cannot reasonably or appropriately be inferred from the mere absence of a reasonable excuse clause.
But I think the Lord Advocate goes further. I think your submission would work for primary legislation, but I think the Lord Advocate goes further to say even if one reads this bill as requiring the Department of Health to list a clinic if it's notified by the operator of the premises, nonetheless, because this is subordinate legislation, the exercise has to be gone through again at the clinic stage and at the Department of Health stage.
Well, my lady, it certainly has to be gone through at the court stage, in the sense, not the same analysis that the Assembly went through, but the court certainly has to undertake its own proportionality analysis on the facts, because, of course, there's a clear difference between the proportionality in general terms of a provision and the proportionality of its application in a general case, and that's the case of MM. In a particular case, yes.
So what would be the effect on this analysis of a decision by this court that the legislation is proportionate in the sense that 100 metres is proportionate? If we were to reject the attorney's arguments on, well, it could be done by a less intrusive measure, what would be the effect of a ruling of this court that it is compatible on those grounds rather than on the grounds put forward by the Lord Advocate on the exercise that would need to be carried out in the Magistrates' Court?
Well, my lady, again, I can only, by reference to the case of MM, I think that's so. As a general rule, the court can say this is proportionate. It's proportionate as a general rule. It's not disproportionate to have safety zones outside an abortion clinic. It's not even disproportionate to have safety zones 100 metres or even potentially up to 250 metres outside an abortion clinic. But the court needs to undertake that assessment on the particular facts of the given case. And my lady asked for some examples earlier, and just as a few examples that spring to mind. Somebody who undertakes a solitary kneeling protest 90 metres away from an abortion clinic at 7:30 a.m. in the morning, holding up a holy picture. Now, they may be reckless as to whether a doctor who was going to turn up early for work might see them, but a court, if faced with that kind of prosecution, a court might well apply a different proportionality analysis, or the proportionality analysis applied by a court at trial might be different in those circumstances to people who are accosting people coming in and outside of an abortion clinic. Similarly, and my lady will be much more familiar with the geography than me, but if one were to draw a 100-mile radius around the 100-metre radius around the abortion clinic on College Street, one would take in part of the front of Belfast City Hall. 250 metres would take in a Catholic chapel and the whole of Belfast City Hall. And so again, a court faced with somebody who's leafleting outside the Catholic Church or getting a petition signed outside Belfast City Hall might well treat that very differently, again, to people who are accosting people outside of an abortion clinic. And that's what the proportionality analysis at trial enables. It enables there to be this broad legislation, but it prevents people being prosecuted for or being convicted for what would otherwise be, in a manner that would otherwise be disproportionate in relation to their Article 9, 10 and 11 rights.
So would this have to take place in every case?
Well, my lord, in some cases the analysis might be pretty swift, but in other cases it would be more detailed. But the Strasbourg case law says that there need to be sufficient reasons given in relation to any interference with Article 10 and 11 rights. So the court would at least have to make a determination on that at trial. Because, as I said, the court, as a public authority, cannot act in a manner incompatible with convention rights. So it cannot convict a defendant where that would constitute a disproportionate restriction of their rights. But it also can't turn a blind eye or delegate that responsibility to another public body or indeed to the legislature. And I won't, I'll ask the court to read it, but not at this moment, paragraph 69, where the court in Couturian gives another reason why it can't accept a general freestanding obligation under Section 6. And again, with respect, it is simply wrong. It seeks to carve out another exception from Section 6, which just isn't there on the face of the authorities and isn't supported by any authorities, and which suggests that a court doesn't have to be satisfied that it would be disproportionate. Well, a court does have to be satisfied, because otherwise it will itself be acting unlawfully. And the House of Lords case of AG reference number 2, again, no need to turn it up, it's at page 115 of the supplementary bundle, is instructive in that regard. And that concerned an Article 5 case rather than an Article 9, 10, 11 case concerning delay. And the relevant paragraphs are paragraph 30 per Lord Bingham and 35 per Lord Nichols of Birkenhead. And they underscore that courts exist to uphold the law. And it can never be proper for a court to act in a way which Section 6 declares to be unlawful, i.e. in breach of convention rights. And given that it would be unlawful, as I say, the court cannot rely on the assessment of another body. And there's one case that would be useful to turn up. It's at tab 64, page 646 of the supplementary bundle. I have the... I think that reference is wrong. So it's tab 64.
If the offence is statutory and there's no element of lawful excuse or reasonable excuse to worry about, if it's statutory, unless you can alter its meaning by using Section 3, the court just has to give effect to the statutory provision.
Well, my lord, the point is that it is possible to read it in a manner compatible with Articles 10 and 11, which was demonstrated in the case of Lee Brown. A court must act in accordance with Section 6.1 unless it cannot do otherwise. And the cases make clear that it is possible to interpret it in a manner compatible with Articles 10 and 11, and so it should. And this case may well be assistance. It's the case of Weyer. It's at page...
That's got nothing to do with this.
Well, my lord, it does, in the sense that it's a Proceeds of Crime Act case, and it is equivalent to here because the legislature, and here Parliament, had acted to remove the discretion from the Crown Court in the Proceeds of Crime Act. And nevertheless, and this is at page 646, what the court says, and this is at paragraph above the letter B, Section 6 of the Human Rights Act imposes on prosecutors the duty not to act in a manner incompatible with convention rights. So the Crown has an important preliminary function in ensuring that a disproportionate order is not sought. But the safeguard of the defendant's convention rights under A1P1 not to be the object of a disproportionate order does not and must not depend on prosecutorial discretion, nor on the limited jurisdiction of the High Court. Mr. Perry and Lord Pannick were correct to identify the repository of the control in the person of the Crown Court judge, subject to the review and jurisdiction of the Court of Appeal. And so we do say that is very relevant, because, as I said, that was a case where Parliament had legislated and reached a balance that Parliament considered to be appropriate. But nevertheless, in order to safeguard convention rights, the court effectively read into POCA a provision that it had to be given effect in a manner compliant with A1P1. And that foreshadows the judgment in Ziegler, where, again, no need to turn it up, the reference is paragraph 57, page 484, where the court said that the magistrates' court judge is a public authority and it is his assessment of proportionality of the interference that is relevant. And that is with respect why the court must itself be satisfied of the proportionality in a given case.
I recognise you're obviously short of time, but I mean, I was in where was that not to do with the exercise of a discretion by the court?
Well, my lord, certainly the way what the court says at paragraph 4 was that, and I can turn this up, it's at page 640, and 3 lines down paragraph 4, the 1995 Act removed from the Crown Court almost all discretion as to the making or quantum of a confiscation order.
Yeah. Yeah.
So, in fact, POCA had removed the discretion.
Well, almost all discretion. Well, it was a specific provision that was that Ware was concerned with, to do with how the court responded to an application for a confiscation order.
Well, my lord, I don't labour the point.
I mean, I haven't looked at this for 10 years, but I'm just trying to understand what
my lord,
I was talking about.
I don't labour the point. It's simply that the court makes the point that it's the court that is it is in the court that the protection of convention right rests. That's simply the point that I make. I won't labour it any further than that.
Can I just ask you, is your submission indicating that if we were to regard the bill here as convention compliant, that there would be very few cases where there would need to be a proportionality assessment, or are you saying in principle every single case could be susceptible to a proportionality analysis?
Well, my lord, like Section 137 of the Highways Act, or so many offences that have a lawful excuse clause, the answer would be yes. But that doesn't mean that it acts as a get-out-of-fine-free card for protesters. The courts will be undertaking the same balance at court between the Article 8 rights of women and the Article 10 rights of protesters.
Sorry.
Can I just follow that on? I mean, the difference is the Highways Act has not gone through an analysis as to whether it's convention compliant. We're at the stage now of doing that, but we won't look at that's not been an issue under the Highways Act. Once that's been done, once that exercise has been gone through, which is what presumably we're doing here, it would seem odd to me that you would then effectively treat the situation in exactly the same way as you would the Highways Act, where there's been no convention compliant analysis.
Well, my lord, the Section 137 Highways Act was before the court in Ziegler. They would have said if they considered it to be incompatible with Articles 10 and 11. The point is that a provision can be itself compatible with convention rights, but that doesn't mean that it will be proportionate in all of its applications. And that's really, it goes to the animal defenders case in Strasbourg, basically, which is what the High Court is relying on in Katchourian to say that it's well established that there are general measures where you don't have to take into account the facts. And it just simply isn't the case. In the animal defenders case concerned general measures that may apply to predefined situations regardless of the facts of the case. And the court said that was fine, even if it might result in hard cases. But hard cases in animal defenders meant that people might not have their adverts played on the television. And I'm not seeking to minimise the restriction of Article 10 or 11 rights that would entail, but in a criminal context, a hard case means that someone would be convicted even though the conviction was a disproportionate interference with their convention rights. And that's necessarily wrong in my respectful submission. The criminal context is different to the regulatory context, as the authorities subsequent to animal defenders make clear, and those authorities were not before the court in Katchourian. And Dr. McGleenan referred to two of them yesterday. They are Perenchek and Hanziewski, and they make clear that there has to be a detailed factual assessment of the specific conduct and of the restriction with it in order for a restriction by way of a conviction to be proportionate. And that is even where it is just defined, as it was in Hanziewski. And in Perenchek, in a paragraph that Dr. McGleenan didn't refer to, the court specifically distinguished between the animal defenders case and criminal context. And whilst Dr. McLean did refer to the case of Pretty, which concerned a challenge to a blanket ban on assisted suicide, that's plainly completely different. It involved what is effectively an unqualified Article 2 right to life. And in any event, the court in that case did not find that criminal conviction was invariably justified. The applicant was challenging the existence of the criminal offence in abstract. But it's notable that Dr. McLean hasn't been able to refer to Strasbourg authority, where a conviction for breach of Articles 9, 10 and 11 was considered proportionate without an analysis of the facts. And Dr. McLean's suggestion that the ECHR has somehow resiled from Perenchek in Hanziiski also has no merit, and the court will see that we handed up the case of Mukin in Russia last night. That deals with that point comprehensively. The relevant paragraphs were highlighted to the court. But there are also other cases. Al-Khina in Russia is one of those. That's at page 910 of the supplementary bundles, paragraph 228, where the court finds it a breach because the domestic courts failed to adduce relevant and sufficient reasons. And exactly that language is the language replicated in the case of Lee Brown, which is, in my respectful submission, the appropriate approach to these kind of cases. But, my lords, what's clear from the Strasbourg case law is that whenever there's an interference with Articles 9, 10 and 11 by way of conviction, the Strasbourg court consistently holds that it's necessary to have a particular analysis on the facts. And that's not a radical proposition. What would be a radical proposition would be criminal courts convicting defendants for a proportionate exercise of their convention rights.
Well, it's a rather idealistic proposition. Being in the real world, whether the police think it worthwhile charging people, whether prosecutors think it worthwhile going through a trial for the sake of a £500 fine, if it involves all this exercise, may be doubtful, and it may, in reality, render legislation useless.
Well, my lord, that isn't the case with, I come back to section 137 of the...
That's why the CACD in Brown and Kachurian is trying to find a way of avoiding the practical problems that Ziegler has given rise to.
Well, my lord, with respect, it's far from clear that Ziegler has given rise to practical problems. Certainly in the criminal cases that I've been involved in since Ziegler, there have been very limited practical problems. It's been possible to give clear directions to a jury. Magistrates' courts have been able to follow it with ease and with clarity. So in my respectful submission, there isn't evidence of Ziegler having given rise to practical problems on its face. And in any event, certainly section 137 of the Highway, since the Human Rights Act came into effect, magistrates' courts have been doing the exercise that was done in Ziegler, that indeed came to be challenged and came to be before the Supreme Court. And the Supreme Court effectively endorsed the analysis by the Magistrates' Court. There was no suggestion that the Magistrates' Court in that case had got it wrong, that it had been overly burdensome, that this was something that was burdening the criminal justice system, or that it was something that should be prevented.
But it was common ground there that the proportionality assessment should be done under the reasonable excuse defence. That wasn't an issue, was it?
Certainly, what was an issue was whether it was an issue that what the defendants had done did not amount to a reasonable excuse under Articles 10 and 11. That was certainly an issue, and indeed the Divisional Court, of course, held that there had been no, that they should have been convicted, and that was what was appealed to the Supreme Court, and the Supreme Court found that obstructive conduct, even deliberately obstructive conduct, was capable of affording, in effect, a defence in these kind of cases, because it would be disproportionate to convict somebody in circumstances where they were properly exercising their Article 10 and 11 rights. But the thrust of my submissions is simply that an express lawful excuse is not synonymous with proportionality. Dr. McLean's case is that lawful excuse here would be curative of the issues in this provision. Lee Brown makes clear that the correct approach is to have regard to the elements of the offence and then to consider whether or not it would constitute a disproportionate interference with Convention rights. That was the view of the Lady Chief Justice, Sir Declan Morgan, Lord Justice Tracy. That reflected the view of the High Court of England in Wales in Connolly, the view of the High Court of England in Wales in Scotto. And there are certainly cases where lawful excuse has been considered to import a proportionality exercise, and Ziegler is one of those. But if the court goes to the reasoning of Lord Justice Singh in the High Court, he also says the starting point is section 6.1. He uses lawful excuse as a tool then to bring in Convention rights, but that's just how it was possible to interpret the provision in that case. That doesn't mean that it is impossible to interpret provisions otherwise in other cases. And just to return in the couple of minutes that are available, if indeed they are, to James and DPP, on which Couturian relies, Mr. Justice Ousley's judgment didn't refer to a single Strasbourg case. It didn't refer to Connolly. The concurring judgment refers to one case, but respectfully misunderstands the broader ECHR context. And although De Haal was disavowed, the judgment at page 56, paragraph 56, page 370, makes clear that Blackstone's had considered De Haal to be the correct approach in applying the ECHR. James isn't compatible with ECHR jurisprudence. The Divisional Court in Ziegler rightly cautioned that it was to be understood in its proper context, and the Supreme Court in Ziegler didn't even give it any consideration in its judgment, neither in the majority judgment nor the minority judgment. And that is notwithstanding that it was both referred to and quoted at paragraphs 22 and 23 of the appellant's case in that case in which I was instructed. Now, it cannot properly be suggested that in what my submission is a flawed approach in James, to which the Supreme Court didn't even refer, underpins the entirety of its judgment. And in my respectful submission, Couturian is in error through focusing on the elements of the crime, which is precisely what was warned against by Lord Steyn in Gaydon Mendoza, that it was not a literalistic approach, wasn't appropriate in Convention cases. And for that reason, Justice respectfully submits that the lack of a reasonable excuse clause should be no bar on this bill becoming law.
Yeah. Yes. Well, she just said it. The approach of evaluative judgments. You've got a note of them, I think. Okay. I mean, what supplementary submissions?
Well, you offered to give us some supplementary submissions on evaluative authorities concerned with evaluative judgments.
Yes, indeed, my Lord.
We'd be willing to entertain those submissions. Obviously, they'd have to be circulated. Again, if you could let us have those within 14 days.
My Lord, might I ask the permission for the court for 21 days, just if that wouldn't inconvenience the court too much?
Yes, very well.
So that is on the point about whether the proportionality question is a fact of law, is a question of law fact.
Yeah.
Thank you.
Yes, Ms. McLean.
My Lord, my ladies, there is an issue arising about the role of this court, in this context, and we are here dealing with a reference by the Attorney General under the devolution statutes. Parliament has entrusted the court with a particular supervisory function over the devolved institutions with respect to their law-making powers, and against that background, we say, wary of suggestions that the court should be adopting a self-denying approach or high thresholds, or in fact deferring these matters for further consideration by other courts. The Attorney General has referred this matter before the court. The quality and extent of the debate yesterday and today illustrates that these are proper issues for consideration by the court, and there would seem to be little merit in deferring the issue to be dealt with elsewhere. The value of the process under the Northern Ireland Act and the Scotland Act is that we bring the matter here for expeditious consideration. The attorney could, of course, refer it after it's had assent, or could refer it in the course of proceedings, or we could wait for litigation to arise. But arise it will, and we will be here, no doubt, in years to come. The time to address the issue is, we say, now. Against that background, we have heard considerable debate on an ab ante threshold to be applied in cases of this type. I would observe that there is one authority which I think hasn't been opened to the court yet, and that's the decision of the Supreme Court in the Welsh reference in 2015 on the asbestos diseases. You'll find that at page EF 1334. And the interesting thing about that case is it's another pre-assent reference. It raises legislative competence issues on the scope of powers in terms of the reserved accepted matters, but also on proportionality. So there's an A1P1 convention point in that case. And the Supreme Court, 1334. So this is a devolution issue referred by the Welsh law officer in respect of legislation on both scope of powers and convention compliance. The court did not refer at all to any need for a heightened threshold or to satisfy a high hurdle in order for the issue to be grappled with. The court dealt with the proportionality point, and the judgment of Lord Mance, it's a leading judgment, deals with the issue and concludes that the provisions in question would be outside competence on compatibility grounds, and didn't get into any of the analysis of the numbers of cases or the metric that should be applied in order to make such a finding. Now, the court also found, or primarily found, on the excess of powers point, not the convention point, but certainly the majority in the case was prepared to take that course. Interestingly, Lord Thomas and Lady Hale also concurred in respect of the convention compliance legislative competence issue, so they too would have found that the legislation breached the equivalent provision which we are relying on in this context. It's particularly interesting in the sense that that decision of the Supreme Court in 2015 was essentially contemporaneous with the Beebe decision, which is found at EF 1399. Beebe was heard before the asbestos reference. Judgment was given in the reference first. Beebe's judgment was given in November of that year, and Beebe is the source for the Christian Institute or Christian Advocate Institute issue in terms of the high hurdle threshold. So in the other significant example that we have in the Supreme Court of a pre-assent convention compatibility reference, Supreme Court applied no threshold. And Beebe, which is the source, was a case of a similar composition of the court decided similarly. Now, what we say about high hurdles and thresholds, we've developed a submission yesterday. Our submission is what the court's looking for is, as per McLaughlin, a legally significant number of cases where there is likely to be a compatibility problem arising from the application of this particular section. And it's interesting in the examples that were discussed this morning, I think there were 5 examples discussed. Each of those examples involve cases where the actus reus of the offence would readily be made out in every case, and a case brought forward for prosecution would find that the evidential test was met and the prosecution would proceed unless the prosecution service applied some public interest analysis, which in light of the terms of the statute, it's difficult to see how that could result in any other outcome than the prosecution proceeding. So those are all cases where Article 10 and 11 rights would be engaged, and they're all cases where difficulties would arise. Interestingly, the example when Lord Burroughs gave of the putative father, who essentially prevails upon his partner not to go through with the termination, is a scenario which would also engage Article 8 rights in that context. So it's not just 9, 10, 11. There may be a scenario where there are competing Article 8 rights in play. So,
Mr. McLean, can you refer us to the specific passage in medical costs for asbestos diseases where the test is formulated?
the test isn't formulated, my Lord, is the point. There is no test applied.
Test at all?
No, they don't apply
They just go on to assess it.
yes, straight through. Yeah, there's no issue there.
It was a one-off provision, wasn't it, imposing a liability
On insurers.
insurance companies to contribute to the costs incurred by the health service in treating mesothelioma victims.
Yes, and it was an A1P1 challenge. So it's, again, slightly different, but we are searching for consistency. Those who advise and looking for the approach here, we see that in that context, no one had to satisfy a threshold condition.
Yes, but it's rather like the Scottish AXA case. It was a case where a measure was going to affect a particular category of bodies, insurance companies, in an identical way in every case, and you could determine the proportionality of that. Whereas BB or Christian Institute, or this case, it's going to be applied to a large number of individuals whose circumstances may differ.
Yes. Yes.
I'm not saying that's the reason why one can't form a view, but it's at any rate it's a different type of situation.
My Lord, I think our submission is we ought to be wary of erecting barriers to the court's consideration of a reference brought by a law officer. These are not adversarial proceedings brought by parties. The law officer has formed a view. I say the court has a role in superintending the devolution settlements. The law officers have a role to be vigilant, eternally vigilant, for possible erosions of rights, whether they are Article 8 rights or whether they're the wider rights. So for those reasons we say there is a reason to be cautious about these sorts of hurdles being erected.
It's also an important point perhaps to be made. I mean, the only example that struck me as having any substance is Lord Burroughs' example of the boyfriend who wants his girlfriend to keep the baby. But we've seen in the Strasbourg authorities that we were taken to, I think by yourself, that a measure may be proportionate despite the fact that it results in some hard cases.
Yes.
And we've got ample authority for that domestically as well. An example being the case about student grants. Offhand, I'm trying to remember I can't remember the name of it offhand. It's one where Lord Sumption and I dissented.
Tejere?
Yes, that's it. That's the case. Yeah.
Yes. There will be. I accept that is an approach the Strasbourg Court has taken.
Yeah. And the fact that there may be the exceptional hard case isn't inconsistent with the proportionality of a uniform measure.
Well, caution on that point, we would say, because the court's looking at it through a particular paradigm of the hard cases that come to court. The Strasbourg Court also looks at the chilling effect of the legislation. If you have a low threshold criminal liability, it might give rise to some hard cases, but what it will equally do is dissuade many people from taking courses of action they might well have done. So we don't see the visible hard cases, but there is in fact a chilling effect on people influencing or assisting or engaging with others. And I should say, on that point, the Human Rights Commission have taken the court to what they say is the context of all of this, and that they've given some reference to the CEDAW report. It's not irrelevant here that the legislation that made provision for termination of pregnancy in Northern Ireland was not brought forward by the Northern Ireland Assembly. It was brought forward by an act of the Westminster Parliament, one of the three acts that allowed for the continuation of devolution without an executive. And as part of the deal, in respect of that, the statute is at tab 47, page 1742. You will see, in order to maintain this very peculiar arrangement of no executive, no assembly and devolution, Parliament enacted legislation, and as part of a private member's amendment, the provisions were brought in terms of respect of termination of pregnancy. So it is still politically contentious in Northern Ireland.
There are problems about its implementation, haven't there?
Yes, it is politically contentious, but this goes to the question of whether or not there are other values in play in closing down scope for protest and debate. It's not simply the case that this is a settled position, democratically endorsed in every way. It is and has been an issue of some controversy, and it's important to allow for some scope for ventilation of peaceful objections to that. And the attorney's concern is that 5.2a goes too far. 5.2b and c capture the graphic examples in large part that the Commission have opened to the Court. We don't say that reasonable excuse is the only curative. There are other ways in which the legislation could be addressed in order to make it proportionate. For example, the Human Rights Commission, in its own evidence to the Health Committee, and you have this in the bundle at page 237, contended for temporal limits. Their view was there were problems with the legislation as proposed, and there was a need for some temporal constraint. Now, that hasn't been enacted.
When you say temporal constraint, do you mean that the zone only operates certain hours of the day, or that it only operates for a year? Or?
Well, there is no end point. I suggest that it could be done both ways. There could be temporal limits insofar as the zone is operative during the clinic opening hours or during working days, or it could be temporal limits on the basis that it expires after 6 months. None of those features were put in place, and certainly the Human Rights Commission were arguing for them whenever the matter was before the Health Committee. So it's not the case that the only palliative is reasonable excuse. Reasonable excuse is one means of dealing with it, but not the only means. If the Court reflects for a moment on the contention about what would happen if we say the solution to all of this is proportionality balancing by the other public authorities, reflect for a moment on what's involved in a safe access zone. There are a number of actors. There's the operator, who may well not be a public authority. There's the health trust, who will own the facility. They may have to make a judgment on the proportionality contention. There's the department, who will have to make a proportionality judgment on whether they maintain the list. There's the police officers, who decide whether or not they take action by way of arrest. There's the PPS, who have to decide whether or not to bring a prosecution, applying the public interest test. And then there's the court. 5 or 6 layers of proportionality judgment on the cases that my learned friends are making would have to be made, each one of those being a challengeable public law decision. In our submission, one sees in Kerkurian the Lord Chief Justice striving to achieve workable solutions. What's suggested here by way of a proportionality ex post facto or ex after the fact assessment is a recipe for paralysis. It will be a situation resulting in endless litigation. And one of the reasons the attorney brings this forward, the attorney is not seeking the failure of the bill. The attorney is recognising the need for protection for the Article 8 rights of women, and a viable bill, a sustainable bill, is one that does not have an attritional battleground for public law complaints built in. And we say that's what arises in this context. So the answer is not, we say, to have the proportionality exercise on a rolling basis thereafter, for those pragmatic and practical reasons. It's also, we say, not the answer for doctrinal reasons, because you only get into an application of the proportionality analysis if you use Section 3 to read that mechanism into the statutory scheme. And how do we read that mechanism into a statutory scheme which is absolute in its terms? No scope for reasonable excuse, mandatory obligation on the department. The reading in would confound the well-settled Guyton-Godin-Mendoza approach, because it would involve going against the grain of the legislation. It's not what the Assembly intended. That's the difficulty with it. So we say that's not a solution for pragmatic, but also for principled reasons. It's also, in our submission, something that abrades with the settled line of authority in Kerkurian. We're having now something of a proxy appeal on that point. The attorney didn't bring the reference to have that outcome, but it may be that's an issue the court has to grapple with. But that line of authority stretches back. It is reasoned and well thought out by a divisional court that has looked at it systemically and determined that this is a viable means of operating the criminal justice system with offences of this nature. Set against that is a line of authority starting with the decision in DPP and Connolly. I'm not going to open it, but if the court looks to that, you will see it's a case where Lord Dyson essentially was looking at the Section 3 mechanism and reflecting on what it could do, perhaps too expansively, if you look back at it. The next case that applies it is a case called Scottow and DPP. It's a 2020 decision, nothing in between, and it simply adopts the same approach. So there's nothing like the same systemic analysis in the competing line of authority. All we say on behalf of the attorney is there are two lines of authority. The one which appears to us to give the most coherent reading to the application of these criminal offences is the one that results in the Couturian decision, and the court can take that course.
So you say Couturian was right, and because of that, if this bill is to be made compatible on the basis that there shouldn't be these 5 or 6 opportunities for review, then the best result would be for this court to say this bill is not compatible as it stands, but it would be if it had an express reasonable excuse defence. Is that where you get to?
That's an optimal outcome, we say. An optimal outcome reflecting the balance of rights that's actually in play in this debate. Because a number of the other options here, including the option that's suggested by the Lord Advocate, which is that the departments decide not to have a zone. Deciding not to have a zone, how does that assist the Article 8 rights of the service users who have to go? What that means is you actually erode the entire content of the bill in terms of achieving Article 8 protection. Those are not solutions which we say recommend themselves. But what we ask the Supreme Court to do, of course, is make a judgment on competence. What happens after that is for the Legislative Assembly, if it constitutes itself, to grapple with.
It's ultimately a reconsideration you're asking for, is that right?
It goes back to reconsideration stage. Now, there will be a need to look at Assembly standing orders, suspend them because we've come to the end of a mandate and there's a new mandate. But there is a mechanism with political will where the bill goes back with the view of the court and the Assembly takes the next step that it considers.
To an Assembly that is sitting?
Yes. None of us can control that. All of us wish for it, but if that Assembly is sitting, the consequence of a ruling on competence of the nature that I'm arguing for is that the democratic process picks up where it left off and judgments are made properly informed. And when one reflects back, I took you through the history of the bill, you can see very limited analysis, proper analysis of the convention balance in the debates, and actually very little advice given, and none from the law officer that was directed to this issue formally. So the Assembly would have the benefit of the court's consideration of the issue, and that's exactly what Parliament intended when it put the Section 11 power in the Northern Ireland Act. This is the constitutional arrangement functioning as it should, and functioning as it should in a context where it will actually enhance rights protection for the vulnerable women and also for those who have a legitimate right, we say, to protest.
Can I also ask you, Mr. McGleenan, something I had forgotten to ask you? Had the Attorney General thought about the nature of a reasonable excuse in these types of cases, and does that coincide with the discussion we've been having about potentially disproportionate convictions?
The Attorney General had no formal role in advising on the legislation in this case.
No, I mean in the context of this.
Of this?
Yeah.
Yes. I mean, it is the reason why we've referred the 5.2a question is partly because the amendment number 4 could have addressed the issue. Now, there's a difficulty with amendment number 4 in a sense, in that it would then still require a proportionality balance to be carried out by the court, but that would be, again, the will of the legislature, not an uncontrolled arrangement in terms of proportionality assessment. So that is a possible means of dealing with it. There are other ways of dealing with the proportionality imbalance. The concept of indirect influence is a concept which the court might think is too elastic or too ill-defined to form a proper basis for criminal liability. So there are elements to the offence which could also be adjusted, or the temporal point which Lady Rose has raised with me. The issue of next steps, of course, it's a matter that will require developments politically. But there is, we say, a proper question before the court. The court shouldn't erect hurdles and thresholds to it, and the answer, we say, suggests itself in terms of the overall analysis. On the question of sight and sound, my Lord Reid has raised the Australian authority, which touches on that issue. Now, make a simple point about that authority vis-à-vis the Convention authorities which speak to sight and sound. Under Section 2 of the Human Rights Act, this court's obliged to give effect and have regard to the Convention jurisprudence. It doesn't have the same obligation in respect of common law jurisdiction decisions, no matter how well considered and reasoned they are. But the short point on sight and sound is that the Supreme Court in Ziegler, and there's been some implicit criticism of it today, the Supreme Court in Ziegler endorsed and emphasised the sight and sound consideration. It actually quotes the Lash-Mankin provision, and clearly the Supreme Court in Ziegler considered that the right to protest within sight and sound was an inherent part of the Article 11 right, and its judgment appears to have been an endorsement of that position. So while there is Commonwealth authority which takes a slightly different view, our Supreme Court has adopted and endorsed the sight and sound concept in Lash-Mankin, and we say that line of reasoning should carry greater weight than the observations of the Australian courts. I also say, of course, we don't know, and one of the difficulties of looking at cases from the Commonwealth jurisdictions, we can only see from the report. We don't have a full knowledge of how that statute actually works. In this case, we're saying the court should look to Section 5.2a, but we're also saying it has to be read in its context. We need to see the entirety of the bill. How does it work? What are the temporal limits? Who reviews? Who makes the decisions? It's, we say, potentially difficult to make an assessment on Australian statutes when we don't have a full understanding of how they're meant to operate. So,
well, I think I can probably get a better grasp of the Australian statute than I can of the laws governing protests in Russia.
Well, indeed, my Lord, I understand that. But the obligations on you are clearly more sharply defined in respect to the Russian statute. My Lords, I think I've addressed the points I needed to address in my reply. Unless the court has questions, I'm grateful for the courtesy which the court does to the reference.
That's very helpful. Thank you very much, Mr. McLean. Well, we're very grateful for the submissions we've received, and our gratitude extends to not only to those in the front row, but also to those sitting behind them, who will have contributed a great deal, I'm sure. We're conscious that there is a bill which has been passed and only awaits our judgment either to be reconsidered or to go forward for royal assent. So we will deal with this as quickly as we can. That said, we've allowed you some weeks to put in additional material, and there will be some disruption of our normal ways of working because of the fact that we're in the long vacation in just over a week's time. So I wouldn't realistically expect a judgment before the autumn, but we'll produce it as quickly as we can. Court will adjourn.